prepare letter and next week. Next week of the letter next week. Why? Letter is regarding not the contractor's bill, so to supply diesel to the district administration. The next week I am not there. I don't Friday. And should be maybe okay, let it be on 25th. The order was first booking the description of the IPA section 17B and it was duly communicated to the management. Where is the requisition? Spending and what is the requisition number? 3102 of 2020. Huh? P1? P102. Where? That is not correct. Even in the mention in the content division. Because I have filed the content from the. And what is the article 125? Hmm? Who has filed a requisition? Management. Management has filed. I am the workman. Is this matter along with WPC number E102 of 2025 on Friday? Huh? What's it? Pursuant to what order method, petitioner has completed certain works under the method water areas development department and executed by the PWD method. Work order in page 22 and accepted. This is of 2021. How much? 2,50,000 all given. 2,50,000. Why you have only prayers, interim prayer also? Huh? To a direction to the to pay interest. Here the action of the going on. Direct the police order, complete on renovation, and then ask them for the directing you have to pay compensatory for. Then interim direct to release forfeit the admitted amount. Anything more? Huh? So many players. Simple aspect. 2,50,000. Which department? My lord, PWD and my lord, border department. Huh? Border department is also there. Border? Yes, ma'am. PWD and Border Protection and Development Department. Whose part belongs to Border Protection and Development. Who appears for Border Protection? Government. You and PWD. And then notice returnable on 14th of September 2026. What is this matter about? Yes, Mr. Mudunda. We don't have the file. Lordship, let's have it on next week. Lordship, I pray, Lordship, at least in letter notice that issue. I don't issue notice just for the sake of it. You Lordship, know the story. Sorry, Lordship, we'll have it on Wednesday. Oh, Lordship. The request of the learning council for the file. You got a file? Okay. Here. What is your case? Lordship, regarding the submission of application for permission of opening of a pharmacy college, Lordship, but it is in the online portal. While submission of the online portal, Lordship, they impose a certain condition of NOC, which is not in the Act and rules, Lordship. So at this stage, Lordship, I pray later notice that they should have to file their affidavit. So you want to open a pharmacy college, Lordship, and we want to submit the application on online portal of the Pharmacy Council of India. Yeah. But while going through that, Lordship, they impose some certain condition that is the NOC of the state. But in the Act and rules and entire notification, there is no such condition as they have raised now. So online portal, Lordship, we cannot submit the application, for which I filed the application petition. At least they should have to say something on that, whether on what condition the online portal NOC. But you are asking the NOC from the state NOC. Lordship. State NOC will be the Pharmacy Council of here. Why you are not making the Pharmacy Council of Assam? No, actually, we are now at the end to stage the grievances against the Pharmacy Council of India on online portal. Understood. But you are saying that the pharmacy, the NOC from the state NOC, from the Pharmacy Council, because Assam also has one unit. That unit's NOC is required. Now, you say that NOC should not be insisted upon at this stage. Whatever stage. If you are asking that, don't you think that that Pharmacy Council of Assam is a necessary party? Lordship, Pharmacy Council, I made a party. Or Pharmacy Council, the Pharmacy Act, Lordship, what I see this Pharmacy Act, which say, I have annexed also that, Lordship, the Constitution of the Central Council, okay, Lordship. Then there will be a state council. Where is the state council? Normal, with all respect, Lordship. Normally, first of all, we should have to take approval from the Pharmacy Council. then the state will come. Yeah, the state pharmacy council. The state pharmacy council has to be a party. That is not under the state. It is under the pharmacy council. Understood, but they are asking for an NOC from the state. Not in the act, Lordship, but only in the portal. Understood. They are asking, insisting on an NOC from the state pharmacy council. My question therefore is, if you are saying that the NOC from the state pharmacy council is not necessary, you are saying that this is your prayer B. I see your prayer B. Issue a written amendments are now appropriate to read direction directing the respondent to allow the petitioner to submit his application for approval of a new pharmacy council without insisting upon the prior state NOC. Lordship. State means the state pharmacy council's NOC. But not state pharmacy council, Lordship, the government, state government. So and I am only on paragraph my prayer. So if you are asking the state government, you should think that the government of family welfare should be made a party. Lordship. So we have not made, but first of all, I should have to take approval, then the state question of state will come. Rule 12. Understood. You are asking that an NOC from a particular entity is not necessary. Are you not asking that? No, I am just applying on online portal of the pharmacy council, Lordship. Submission of my form. While the submission of the form, they impose a condition on the online portal, but not in the act, and directly it will submit the application. Mr. Mudunda, I understand. What is your case? Your case is for purpose of applying for a new pharmacy college. There is no necessity of obtaining the permission from or any NOC from anybody. That is your case. Now my question is, if you are saying that no NOC is required from the state government, don't you think the state government has to be heard? Lordship, that the correction, Lordship, I pray, Lordship. Only one question is that I should have to take first of all approval for opening of the pharmacy. If they grant the approval, then the next stage will come for the state. Subsequently.
Repeat your words, sir. This is the, I don't know whether the subject matter is same or not, my lord. Earlier, the Honorable Court disposed of the matter, my lord, that in the same, but I don't know. Can you fix it on Wednesday? I'll provide, but I don't know whether the subject matter is the, in that case, state of Pharmacy Council of State and Pharmacy Council of India both are the party, my we're the party. So I don't know whether the subject matter is the same or not, my lord.
That was
This is the
start. With all respect, Lordship, that
council was different on that time, my lord.
Application, prior petition, so as per section 12 of the Pharmacy Act. Lordship. So as per 12, Lordship. Section 12(1), Lordship. First of all, the central government should have to give the approval. Lordship. You are asking for the approval. Lordship, only approval. Not on for opening, Lordship. Then page 35, Lordship, approval of the authority conduct in the course of study. Subsequently, that part will come, Lordship, for which I have not made the part, state government as a party. Now, kindly see any authority in the state, Lordship, which conducts a course of study for pharmacists. May I apply to the Central Council? Do you conduct any course of study in Lordship? We want to conduct. You want, here it says which conducts a study. Means it is conducting.
We are not yet conducting.
Therefore, how do you come on the 12th?
Which conduct a course of study, conducts a course of study.
May apply to the
May apply to the
approval of the
center.
course.
Center company.
So if you are conducting a course of study, you may apply.
We interested to conduct. And then page 35 of my petition, Lordship. There is a notification of 2014. 9, clause 9 last, regulation 9, Lordship. Page 35. No person, institution, may I read, Lordship, society, trust, or university shall start and conduct P-Pharma program without prior approval of the fathers. For which, Lordship, I want to apply on their portal. Lordship, then page 42 also. There is a format table. Lordship. Approval of the authority. At this stage only I submit my application. Lordship, on portal. Page 42. Then Lordship also. Page 40. Then after submission, Lordship, candidate should fulfill the academic institution condition.
So they are asking for what approval? NOC from the state government.
State-
Why?
Only they keep a portal on the point, that point, Lordship. Without application, they should have to file their affidavit at this stage. If they'll say that the state government permission is necessary for filing an application for approval, then Lordship, I have no case, Lordship, at all. As per Act, Lordship, that is completely aside.
Notice making it returnable on 22nd of July 2026. Ms. Ada and execs notice on behalf of the respondent 1 and 2.
Yes, madam.
Extra copies of the petition be furnished to her during the course of the day. In the case of the petitioner intends to open up a pharmacy college in the state of Assam. For doing so, the petitioner is required to take approval in terms with section 12 of the Pharmacy Act 1948. Read with the Bachelor of Pharmacy bracket reform course regulation 2014. Mr. K. Mojumdar, the learned counsel appearing on behalf of the petitioner submits that while applying to the online mode, while applying, which has to be done on the online mode, the portals emphasizes on a no objection certificate from the state government. Mr. Muzumdar submits that a perusal of the Pharmacy Act 1948, read with the regulations so framed therein under, would not show that there is a requirement of any such NOC from the state government at the time of application for filing an application seeking approval in terms with Section 12 of the Pharmacy Act 1948. It is therefore the case of the petitioner that the said requirement of obtaining the permission from and no NOC from the state for making an application should be dispensed with. Ada in the learned council appears CDC submits that she would like to file an affidavit after obtaining instructions. Next day to get the by stake, The respondent number 1 and 2 shall file the affidavit on or before 13th of July 2026. Liberty given to the petitioner to file reply therein. Much obliged. Oh, yesterday.
My lord, that matter regarding, my lord, that the pending works, pending as well as, my lord, there is no fund has been provided for continuation of the work, you know. So, my lord, Panchayat and Rural Development is the main party, my lord. And that's why, my lord, my laws to go please go. Pass an order directing the appearance of my lord.
Are these contracts not being given with saying that subject to availability of the fund?
My lord, I have to take instruction, madam. Because just in the morning, I have received.
This is a case where he is asking for
Running.
a running account bill. Running account bill to this court, why should this court interfere now? At this stage, if the work is being done, if they don't do it, they obviously have the option of taking the benefit of Section 48 of the Contract Act, with reciprocal obligations. So why should we interfere? So therefore, the question is, if it is a running account bill, well, I don't think this court should exercise power of the. That's right.
My lord, only, my lord, that's.
If he has given up the work and there is a final measurement, then payment not made. Okay, then the question is different. But he still continuing. That is what Mr. Bhuya said.
50% done as per, my lord, as per the estimate, 70% work. After this 70% no fund, now it is in a, my lord, standstill condition, my lord. I cannot proceed further, my lord.
Now, the question is whether there has been an administrative approval for the work.
I take instruction on that.
These are many
Yes,
things which
without
require.
Financial sanction, work cannot be granted, my lord. But, my lord, the letters and communication says, my lord, they are asking for fund, my lord. Just for a moment, my lord, if my lordship can be pleased to, my lord, turn to page 55, my lord. The letter, my lord, addressed to the commissioner by the chief executive officer. That's page 55, my lord.
How can you say what are you to construct? No, Lord, after this letter, my lord, as there is no availability of fund, my resources, my lord, is almost.
Construction of a boundary wall and drainage system at the proposed new office campus. Boundary wall, 86 left. Now, you have only done the piling.
For filing and other, my lord, this,
Yes, state of affairs. Why they will pay after 4 years, 5 years?
no, my lord, as there is no fund has been, my lord, provided.
Understood. So therefore, my question is, you see here, it says completed 70% of the earthwork
Fine.
and pile construction for me. Now you have to construct the boundary wall. Boundary wall, it has not started at all.
The purpose of construction of the boundary was filing.
What do you say, Mr. Doctor?
It's a very low lying area, my lord, that's why another difficult.
What, Laura, you know about it? As is various condition, you have taken the contract.
My lord. I have to complete it, my lord. My lord, my friend can at least tell instruction, my lord, what is the exact position, my lord.
Right. When you file your application, you have put annexer
No,
7 out there.
No, my lord, my annexer is.
Annexer 7 is in a very critical state of affairs. You have completed the work of the sport.
No, my lord, I cannot, my lord, because now as I have been, this work order has not yet been cancelled also, my lord, till day. So I.
Why will you cancel? As of now, nothing has happened. Because
No,
you
no,
see,
no.
the courts direct, the payment is to be made as per this thing. This comes earlier now. Yes, we are the present leader. This can't happen. This order.
My lord, some, similar orders have been annexed, my lord.
What is this?
Contractual, it is not so very relevant, my lord.
What type of orders you have enclosed, Mr. Bhuya? Kindly see page 63 and 64. Which is the judge who passed this order?
This has been, some inadvertent mistake is there.
Then, this type of interpretation, you
My
don't
lord,
know
my-
head and tail about it.
My-
Mr. Doctor, do you see any hidden
Yes, yes,
tail of
no,
this
no.
order?
Don't know how.
It starts with a contractual dues and finishes with something without a signature of anybody.
That is,
What type of orders are these?
it is some pages.
This we should dismiss with cost now.
No, my lord, it is some pages are missing, my lord. I'll rectify it, my lord.
No, I think we should dismiss with
119 page
cost.
judgment, my lord.
Huh?
119 page judgment. So therefore, they have only relevant person. They have enough.
No, relevant also has no relevance.
No, my lord,
You don't know which judge passed this order. You don't know what is the facts of the case.
my lord, this is an online updated copy, my lord. That's
What online updated
No,
copy? Can't be
online
like
downloaded
this.
copy, my lord.
Tell me which judge passed this order.
My lord, it appears to be Honorable Mr. Justice, my lord, Michael.
It appears where?
Michael Dosar.
Where is the appearance?
My lord, fine.
Mr. Doctor, can you make out that appearance?
No, my lord, at base, my lord, kindly have a look at base, my lord.
Kindly see the next one.
My-
Page 67.
No, my lord, what
Why on earth have you enclosed the Assam Public Procurement Act and only clause 8?
my lord.
Why?
My
This
lord,
type
this is-
of petitions, I don't think we should issue notice.
my lord.
You do one thing.
My prayer is very.
No, only good thing can happen. Next week I'm not here. They will get a kind judge who may issue notice. I don't issue notice to these people. In the meantime, Mr. Doctor, you find out that this is what is there. If it was mentioned out there that it shall be subject to availability of fund, mostly I've seen, then obviously he cannot come out here to ask at this point of time.
Yes.
Unless he says that, okay, the contract stands terminated and no payment has been made. And the work also doesn't seem to be satisfactory.
Yes.
Okay, at the request of the learned counsel, well, it is seen that from the materials on record, it is seen that Annexure 8 is a copy of an order passed by this court. However,
Nothing has been mentioned as to what is the effective what is the, however, the order so enclosed is incomplete. Mr. A.R. Bhuyan, the learned senior counsel appearing on behalf of the petitioner submits that an additional affidavit will be filed bringing on record the said judgment. Taking into account the above list this matter, you have to have it within these 2 weeks, sir. I'm not there. Thereafter, again, nothing is going to happen. On 27th. Subject to filing of the affidavit, additional affidavit bringing on record the said judgment.
My lord, our may be reflected, my lord. And in the last order, it was there, but actually, that was
Your
not
name has
said.
not been shown. Mr. S. Dutta appears on behalf of the Peter's department and submits his name has not been reflected in the policy. The registry shall do the needful.
I do. Right.
In the meantime, you find out this aspect, Mr. Datta. You find out this aspect.
Obliged.
What is this?
I know.
Same type.
Same type, my lord, earlier, 15th, my lord, lordship has issued notice and fixing on 7th, my lord, along with WBC number 2502. Same, out of same administrative approval and same, my lord, was ordered.
Okay, to about to order to Mr. Because you know, on September, na?
7th of September, lord.
No, this is 14. 14. Madam, you are appearing in this matter. Give your name.
6 same, my lord. 5 and 6 same.
This is also 14. What is he asking for, madam?
I didn't understand, he has mentioned respondent number 6. There are only 2 respondents. In the prayer question, lordship will find page 7 also, page 7. Right, in the instant case trial of the case has not yet been covered, the petitioner has not yet been convicted of the fact. As a despite the absence of any conviction, respondent number 6, regarding payment of maintenance costs from the petitioner and refusing to remove the unless a payment is made, which is out. So they were carrying my problems, madam. 32 numbers of cabbage. Then it was intercepted by the madam.
We have it on 15. We have it on. Hey, look at the Monday. I think the last 2 part, one item. The Kosala is the ID. ID listen, sir. This matter is required to be taken to another map.
Not sure.
This matter on none appears on behalf of the petitioner on call. Ms. Yuda, the learned additional senior government advocate, appears on behalf of the
Respondent.
respondents. This the matter on 22nd of May 2026.
Dear letter, my lord, my lord, Satyatika Santiberg, Uglan Bazaar, has been settled with the petitioner's father. That Satyatika Santiberg, my lord, tender has been floated, my lord, and I am the lowest bidder, and part is settled with me, my lord, for the period of 5 years, my lord. And it was started from, my lord, 2022, my lord, from 19/5/2022, my lord, it will be ended on 25/2027. In the meantime, one open my lord, government has taken a decision to innovate the park, my lord. And accordingly, park has been developed, my lord. Now it is complete, my lord. Where the park has been, my lord, renovated, I handed over the park with an assurance that after renovation, park will be handed over to me, my lord. And I am on legitimate expectation, I am waiting for this, my lord. Now I came to that the government.
Legitimate expectation is not a right. Supreme Court has stated in many cases.
My last thing is that, my lord, my lease agreement was not terminated. It was still on. Yes, my lord. Here's my lord, 59 men. Annexer 5 men. I have deposited the security deposit also, my lord, 8,40,000. And they have accepted the security for 1 year, my lord, security deposit. And I have done rent for 7,000. I have given the rent on time to time, my lord. You know, still can become 66, my lord. Only these two can, my lord, they can terminate the payment. 6.1, 6.2.
Which area is it?
My lord,
Which area is this? Where is the area?
some,
Huh?
High Court, my lord, that- yes, my lord.
So there's some park now?
Yes, sir. That is fine.
So there is a park newly done by,
Yes, sir.
earlier there used to be a park.
Yes, now it's a used park. It's more than 350 crore.
Then
You are-
now he wants that park.
He was running the park earlier from the development authority of the tourism development authority. Then the agreement was executed. The agreement, madam. I would like to show only one page 74. Okay, 70. Article page 74. That is article 20.
Go there.
May I say something? As he said, my lord, the correct, he can do anything.
Who?
He can do anything, my lord.
You are
Because,
planning. You are,
yes, sir. That's now here, because it's a used park.
you are GMC.
GMD, my GMD, my lord, not smart city. Smart city. But, my lord, where is
That park belongs to who?
park belongs to GMC's contract now, it's the smart city is running the park.
So it is under the smart city. So does the ATBC
It's earlier it was this tender.
Tourism Development Corporation, does they have any business with that park?
Yes, my lord. Assam Tourism Development Person floated tender, my lord. I do not know why he has said whether Yes, Assam 40 is the tender. Tourism Development Corporation has floated the tender, my lord, without informing to the government. I do not know, my lord. Because, my lord, I know Assam Tourism Development Person under the state government. And tender has been floated. I was the lowest bidder. I got the work, my lord, 70,000 paid. When it was taken by me by the Assam Tourism Development,
Where is the tender?
it's fine. Please 40 law. 40. 40 is the earlier tender by the.
No. Presently,
Presently, my lord, Phase 87, my lord.
it's
Election 9. Yes, my lord. Earlier tender, without my lord revoking earlier tender, earlier contract, my lord. How can they contract?
it's a question of damages.
My lord,
Now the authority is different.
the authority is different. My lord, may I say one thing more? Tell us a candy along. When 82, my lord, page number 82, my lord. Yes, ma'am. May I read, my lord, that paper, my lord? With reference to the subject, I would like to inform you the following regard. Temporary vacation of the premises due to DSCL ongoing project along Gauhati river front. Temporary vacation period. Madam, as your letter dated 3/5/2020, you have requested ATDCL to specify exact period during which you will be required to vacate the property. But it is not possible to specify such period. ATDCL will be in possession, hand over the property only, same handed over to ATDCL by DSL after completion of work. Rent suspension, as per request, it is decided a waiver of monthly rent from December 2022 to aforesaid premises to hand over DSL, ATDCL after completion of work. Property condition return with regard to the request, assurance from the ATDCL that property will sincerely maintained and preserved during the absence and return you at the same condition as it was temporary vacation, subject to normal wear and tear. I would like to inform you that extensive development were undertaken by DSL will develop property at the adjacent area at great extent. In return, will increase the scope, earning come more revenue from the project river from the as it will be possible the property same condition. There were high chances of the property and the nature and character of the property might be changed in the sir. However, you take back any temporary structure created by you at the premises. Provision for extension period is not necessary. Hereafter, I wrote a letter to the final. The managing Assam Supreme Development Matter. That is important matter. I am that in this period, if they want to modify the terms and conditions of the contract, as your lordship has said, a huge amount has been invested and benefit. I am ready to do this, but till to the my this agreement was not my lord cancelled nor revoked. Nothing has been done, my lord. Everything and important thing is I filed an RTI to inform me to whom he has handed over because there are hand and gloves with some other persons of their choice, my lord, to give the part to them, my lord. I am read that representation, my lord. And security division has never returned back to me. 84 please. To ensure the in reference to the ATDCL, I am writing to inform you that this property river fund, some writing at the matter concerning vacation. I would like to purpose I am aware that government recently in the certain development.
In this letter,
Yes, my lord.
the year 2023,
Yes,
3/5/2023,
yes, my lord. Because they have given assurance, I have handed over to them, my lord.
where is the assurance?
My lord,
Where is the assurance that they will hand it, give it to you?
82, 83, my lord.
82, 83, no.
Yes, my lord.
82, 83 doesn't say so.
Because it's tell my mother, general matter,
With regard to your request for assurance from here that the property will be securely maintained and preserved during your absence and returned to you in the same condition as it was at the time of temporary vacation subject to normal, I would like to inform you that extensive development work undertaken by IAP will develop the property and its adjacent area to a greater extent, which in return will increase the scope of the earning more revenue from the project so and so. As such, it is not possible to return in the same condition as there are high chances of the property being developed. Hence, the nature and character might change in future. With regard to the PROCEEDINGS, I'd like to inform you as per the provisions of PROCEEDINGS, the council would hand over the project after completion by the DSL to you for the beginning project for the event and may further extension beyond this period shall be at the sole discretion of ATDCL terms and conditions. Now, ATDCL has no business. It is now been the GSCL says that no, we are not going to give it to ATDCL. Then
yes, my submit, my lord, before terminating my agreement, my lord, they have to hurt me, my lord. At least they have to hurt me, my lord.
no,
My lord,
it's a case of frustration of the contract.
no, my lord, no.
Yes, 56,
My lord, my humble.
isn't it? So 56 will apply frustration of the contract. If the very existence of the project is no longer there, ATDCL may say many things. Go and file a case against them for damages. You are at best a case for damages. We are not going to allow you to stop this. You want to participate.
My lord, when it was handed over to me, they never informed me that this project will, they will to abandon this project. Whether they informed me, my lord, that was not done in the
So
incident.
therefore, ask for damages.
My lord, They have to inform me, my lord.
Sir, it's not a right out there. You have an arbitration for both a.
My lord, may I submit, my lord? I have highly representation, my lord, to the authority. That first you decide all these things, my lord, and I am ready. One condition is that, my lord, there is a lease agreement, and I am ready to new terms and condition of the agreement. At least they should dispose this.
The fact remains, Mr. Chaudhary, the riverfront park which was given to you was a small piece of park, which is now become big. Now you want that small piece of park should be handed over to you, and there will be somebody else managing the remaining.
Oh, no, my lord, that's of that. This is the 6 big hour plan, my lord. When I was handed over, it was 6 big hour plan, my lord. And man, I know these things, my lord, when there's the distance of the park, my lord, because it was a 6 big hour plan, it was handed over. It was the boundary of the park more and less than 6 big hour, my lord. My lord. So on that, my lord, internal change has been made of the park, my lord, particular park, my lord. And I am a, my lord, people from that locality, scheduled people from that locality, my lord. I am doing this business, my lord, for last, at least they should dispose my representation, my lord. And it was forwarded by TDCL to them, my lord. They are doing nothing. And even RTA reply was not given, my lord. May I submit, my lord? That letter, my lord, I have submitted. If you not say allow me. Not a big case for it. Please not say so. You think no more. No case for you. We're supposed to represent the small. Supposed to represent the small. No, I don't give order for the polling. These are other judges. My one of those get a good. But it's not a case for you. My humble service. What about this? I love my humble service. What about this? That at least I am entitled for dispose of representation. My lord, I don't give these type of orders. Because dispose of his representation, then why are you coming here? My lord, my humble service, they cannot treat me like a beggar because big people has come, my lord. You are not being thrown out like a beggar. Beggar asks for things. You are not. You are asking more. You have claims, you go and arbitrate, because now the thing is, it is a different authority who have taken it. You have a ground of promissory estoppel, whatever may be, so there may not be a ground out there. Yes, it may be a ground out there. Go for arbitration. Arbitration is the best source. If you want to. There's no fundamental rights. There's no, when money comes, no fundamental rights is violated. Why not? Why not? Fundamental rights. Hello, let me listen. You don't have a, do you have an agreement with GTCL or GSCL? No. You have an agreement with a delegate. GSCL gave it because GSL was not there when this agreement was handed to the accounting department. But you don't have any right to this. Or Mr. NNB Chaudhary, the council is stipulated so and so appearing on behalf. The S4, I hear no 5 and 4, the number 5 and 6. Not city and 5 and 6. 5 and 6. Something didn't appear. The window. The telegram said there, I don't think they did. The petitioner hearing is the key.
by the actions on the part of the respondent authority, more particularly the Chief Executive Officer, Gauhati Metropolitan Development Authority, that is the respondent number 6, in issuance of a notice inviting request for proposal for leasing of space to set up restaurant of the cafeteria in Swati Radhika Antim Grand Park at Uzan Bazar, Gauhati Plot 1, under the Gauhati Metropolitan Development Authority. So, let me show you why you are fighting this fighting proposal. Because you have been leased out a particular area. Fight it out there for the lease. They are only giving it for the purpose of leasing out space for setting up restaurant and cafeteria. Then,
The lordship kindly come to my addendum, man. Because restaurant cafeteria also might not included in that manner.
maybe,
Correct.
maybe, but then also they are doing. So now you have not been handed over back, no?
Yes, sir.
Therefore, sir, tell me one thing. This property is said to be a property of APDC. Can you see page 79, which is a part of the lease agreement? Schedule. Now, if it is a property of the ATGC, can the GMD do anything?
Found the, I don't know how it went to GMT and thereafter to the DSL, the product. We have changed.
Huh?
That's it. That tax, I don't know, but
Because if it is a property of the ATDCL, ATDCL has an agreement with him, wherein ATDCL says they will return him there in whatever condition it is. So, now, unless we hear that GMD has a better right over this and ATDCL did not have a right, would it, therefore, would it be a case where the GMDA would have the power to issue a notification?
let me think about it. That's why that GMT, but
Where? No, who handed over? The question is who handed it?
that tax, I don't have it much.
So therefore, I think we can issue a notice on this. That no representation disposal. That the
Right, if you did the, it's here, you will be able to,
and don't take further action in pursuance to this.
well, that will.
Don't take
Become
any
the
further
right.
action because you see, unless you see that you have anything to protect, because tomorrow third party rights will accrue. You see, you have issues. Now, first of all, whether JNBA would have the authority, because this property has been said to be belonging to ATDCL. ATDCL is not represented today. So, in absence of ATDCL being represented, now question is, he has a right, if the property is of the ATDCL, then obviously nothing can happen. In that area, which have been earmarked as per the deal, if you want to go ahead with this document, go ahead, but not within the boundaries as mentioned in the lease deed.
Or let it fix it to go and get the entrance. How they can do it. GMT, they have to do the.
It's okay, but only thing is this, we need the ATDC.
That,
There may be an agreement then transfer of this property to the, unless the claim has not been transferred, claim you not have, should the.
Somebody is appearing for the Assam, this secretary government of Assam Tourism Department is there. As understood, but that department, Assam ATDCL is under them. We have it on Wednesday. Get hold of this number 2.
I have seen my one,
Ebola appears, but she's in Delhi, so it makes no sense. And it's very difficult to get it done with a very video conferencing link. So therefore, you get hold of the council who presents the respondent number 2, 3, 2 and 3. No, you don't know. Take an instruction. I don't issue with this. I'll have it on Wednesday. We need ATDCL's presence out there on set. Okay? You ask your secretary to do it because this ATDCL has no other entity except that of respond number 1. So therefore, let them come out because you see, this agreement which is there, this is the area, Schedule A. Schedule A is the area. Unless this has been handed over, they have handed over to GSCL, Gauhati Smart City. Now, whether Gauhati Smart City would also not mean the GMDA, the GMDA entity is a different thing. So, put the Gauhati Smart City, whether the Gauhati Smart City is a party.
yes, or no,
So,
fine.
Gauhati Smart City is a party. Put Gauhati Smart City, give it to anybody else. Is the question. When if the property here, because the thing is, Schedule A categorically says that the property belongs to ATDCL. So ATDCL has to transfer it. Then how is the property transferred upon ATDCL? Government company registered under the company having some from government to ATDCL. And then you get hold of somebody. We need that instruction. There's a copy of the. This is the matter again on Wednesday. But he's done. What is there? I'm not issued the notice till now. Hey, Norma, yes, what is your case? Hello? With your case,
You find out, during the replacement manner of the post of PU in 2023, I also applied on one Governor Mandal and others.
are you challenging the appointment of the private?
Matter because we have the ultimate account matter. When I apply into short for at the 23, the case matter that person who was selected, he doesn't have the qualification at all. He wrote a state certificate in the name of that school said he never where he. Otherwise, in this out of PPI, it was 46. And that man was one first one, also is 20 and exactly. Gaurav Mandal was 35 in his test and 28.3 in Viva out of 20. Otherwise, if he goes out, then I get it. Point. Case of fraud, madam. Where challenging the appointment of the Oranga Mandal, why you are challenging?
Because he didn't have the requisite qualification, but he brought some fake certificate.
What is the qualification required
Class 8 minor as well.
Class 8 for the post of peon? No, madam. What is required? He is class 8 pass only.
Yes.
Then
He didn't have the class 8 pass certificate. He brought a fake certificate. You will also come.
he brought a fake certificate.
Yes, sir.
How do you know?
Yes, man, there is the information on the certificate, fake certificate, he put it, you put the other you are of that school manner. Athena,
At page 23, madam.
yes, page 20. And this looks it no. You can't explain this.
Where is this certificate?
Computer value has been the record of it.
Huh?
Not supposed to be with certificate.
How do you we know that we have a certificate?
You are this one, that you are this one, that this. Should say you are never. No, unless you got the shoes now.
When was it promoted? 2025.
Yes.
Well, let us issue notice making it returnable on 25th June to the question. 25th June 2026. Yes. Mr. Suda accepts notice of the Honorary President Senior Government Advocate accepts notice on behalf of the respondent of that. Mr. G. Wishing accepts notice on behalf of the respondent of three. As regards the respondent number 4. Is it working?
Yes.
You working? Are you sure? When is the appointment letter? That is not there.
Yeah, but he's working on it. I have the instruction to see it. He's working.
Huh?
After selection, he's working on something.
Okay. As regards to respondent number 4, steps be taken by way of speed in 2 days. In addition to that, petitioner granted liberty to take steps by justice related to the registry of the spot upon the respondent number 4 and file an affidavit of service on or before the next day. The petitioner shall ensure that the service by way of trustee is effected upon the respondent number 4 on or before 11th of June 2026. The case of the petitioner herein have said the order of appointment of the respondent number 4 as a peon. To the peon. In the office of the district and session judge Sriram Kadolga pursuant to an advertisement dated 24/8/2023. Mr. R.P. Sharma, the learned senior counsel, submits appearing on behalf of the petitioner has submitted that the basic qualification required for the post of peon is that the applicant must be class 8 pass. Referring to the information provided to the petitioner under the Right to Information Act by the Patil La Gauhati High School, Omega. The learned senior counsel submitted that the respondent number 4 had produced the certificate from this particular school, but the said school have categorically mentioned that there is no such student by the name of Goranga Mandal as per the school records available for the period from 2000 to 2010. The learned senior counsel therefore submits that the very appointment of the respondent number 4 as a peon was illegal, and the respondent number 4 had committed a fraud by submitting a fake certificate. Taking into account the above, the respondents hearing are directed to bring on record their stand by filing the affidavits. In addition to that, the respondent number 3 is directed to apprise this court as to whether any inquiry was conducted pursuant to the representation submitted. Respondent number 2 and 3 are directed to apprise this court as to whether an inquiry was conducted pursuant to the representation submitted by the petitioner on 28/1/2026.
My lord petitioner, before your lordship, is basically aggrieved by an order, whereby my lord his claim for some contractual dues for a portion of work he has completed was rejected by the authorities. That impugned order, my lords, starts from page 71, my lord. Now, my lord, the basic reason for rejection is that, my lord, they were directed to examine the case of the petitioner in terms of an order of the Honorable Court in the earlier round of litigation. Kindly, lordship may come to page 71. Order dated 16/6/2022. The first part I'll skip, my lord. The second part is important. The board considered the letter under reference and found that the rubber board entrusted fencing work of the experiment firm at so-and-so to you for an amount of rupees 10,50,000 by executing an agreement in the year 2014 after accepting all terms and conditions referred in a tender document. Clause number 2. It was stipulated in clause 11.3 of the tender document that in the event of the contract being terminated, the rubber board shall be at liberty to cause the remaining part of the work to be completed by rendering the same, or otherwise the contractor shall be liable to the rubber board in respect of all additional costs and expenses that may be incurred by the rubber board for completing the balance work. Number 3 is very important. The rubber board terminated the contract with you on 3/4/2017. Another date is very important. I think we note. My contract was terminated in the year 3/4/2017. And thereafter, they had made an assessment of the portion of work done by me. Just below that, your lordship, they have made an assessment. Total amount of work was awarded to me was 10 lakhs. The total value of work done by the petitioner for the portion he has completed was valued at rupees 3,32,000, and it was my due. A security deposit of 52,000 was basically the security deposit and the value of unfinished work. My lord, as per their own admissions, the value of the unfinished work was 7,24,000. So they had to give a contract for the remaining balance work to any new person or contractor at a value of 7,24,000 plus if they have additional expenses incurred. Now they say in the subsequent paragraph, there has been some additional expenses at page number, at paragraph of 5, Manoj. It may be noted that board incurred additional expenses to the tune of 14,60,000 for completing the leftover work. Work by you instead of 7,24,000 as per the agreement. Accordingly, board has incurred an additional expenses of 7,35,000. So, Manoj, they incurred 7,35,000 as an additional expense. Plus the balance work is 7,24,000. So total is 14,60,000. Now, Manoj, the point that I'm assailing this particular order is because they say that as they've incurred these expenses, I'm not entitled to the amount that I'm basically claiming, that is 3 lakhs. And they try to say this additional expenses was because of me, that they have to retender it and have to give this contract work to some other person. Now, Manoj, the irony here is that your lordship will see that my termination was done in the year 2017. Now, for 5 long years, the authority was sitting idle. In 2021, the new tender was total. And in 2022, I'll come to the date, they have given the contract work to a third party. In the meanwhile, I was before this honorable court pursuing that my so-called claim should be considered. And this court, while my lord hearing both the parties, have given an order that the authorities should see whether I'm entitled to this amount of 3,32,000, and they should take a call that whether I'm entitled to this. Now, one of the point here that I'm trying to raise is that, my lord, for 5 long years, they were sitting idle and they allowed a price escalation for this project in question to rise from 2017 to 2021, which was not in my hands, my lord. Basically, if after termination, they would have immediately, because they wouldn't be exercised legal. No, I'm not on that one. I'm on there to. Yes, madam. Why should they exercise the legal taking madam? But they have imposed the risk and cost after a particular wrong. Now, there must have been a term that if you are terminated of that, remaining work would be done at your disposal. The work was done later on, or 2021 or 22, the work was done. Now they have come up with that particular amount that they have to spend an additional rupees 7,35,000 in addition to rupees 7,20,000. Correct. This is the they see. Correct. Now you say that it is very unfair for them that they are now trying to take up this work in the year 2022. Which they could have taken immediately. It is a case of mitigation of losses. Why should this court look into this? Yeah, absolutely, my lord is correct. But only prayer, my limited prayer is that, my lord, the findings that they have arrived at in pursuant to this order of the honorable court needs to be interfered with. And then the part that if you want to claim for the remaining part of the money that I'm entitled to, my lord, we can always pursue before that is civil court. Why should you this court interfere? Because, my lord, these findings will, at the end of the day, my lord, will create a prejudice to the. No, for that you're going before the civil court. But the findings, civil court, you will say many things. First, the amount which is being charged now, there has been see, one of the basic aspects for what is risk and cost. Risk and cost is a measurement of damages. Correct. Now, it is measurement of damages which is being done is sought to be taken. There has to be also, this is a case of breach of contract, the damage under 73. Correct. If it's the damage under 73 or 74 in the case, there has to be a mitigation. If you don't carry any mitigation of the damages, you are not entitled to the same amount. So you are therefore, you have to go to the civil court and say that this particular document is wrong. You are entitled to this. I give you the lead to that effect that this will not, this court is not entertaining. However, the petitioner is that we go to approach this. And he, of course, my lord, if at all your lordship is pleased to incline to pass some observations, but the fact that, my lord, the way they have rejected the claim and the way they have basically given the contract to the other person, my lord, already the work is done, my lord, kindly if your lordship sees, my lord, they said that the reserve price for this contract was 17 lakhs and some odd. That loss that they have suffered was 14 lakhs. And the tender which was ultimately given was, the third party was 15 lakhs. So there is no uniformity in actual loss that they have accrued. In the
Mr. Verma, I'm not going to listen to all these things here in this petition.
because
Go
they-
file a two, one by two times, I'm here to putting in bench.
then one of the,
Let us please allow this dispute to mature to a very proper one.
then my lord, I leave it to your lordship, then in that case, my lord, I may be not what thanking.
It is heard with the Guragaon Colon Council hearing on behalf of the petitioner. The petitioner hearing is agreed by the actions on the part of the rubber board in not only rejecting the claim of the petitioner to the amount of 3,32,300, but also informing the petitioner that on the other hand, the petitioner has to pay an amount of 4,03,207. The learned counsel appearing on behalf of the petitioner submitted that the action on the part of the responding authority, particularly the rubber board, is privacy, it's arbitrary, taking into account that the risk and cost which is sought to be imposed upon the petitioner has been done at a much belated stage, and thereby the actions on the part of the said rubber board is not fair. Full stop. This court has duly taken note of the aforesaid aspect and is of the opinion that the instant dispute is purely a dispute of civil nature. The question as to whether the respondent's rubber board would be entitled to recover any amount from the petitioner of an amount to the tune of rupees 4,03,257 from the petitioner, or for that matter, whether the risk and cost could have been imposed upon the petitioner after a long lapse of time, as has been contended by the people, are questions of facts which needs to be not only dealt with before a court of competent jurisdiction having with a jurisdiction wherein evidence can be laid, but also is primarily a case of breach of contract and damages and claim for them. Under such circumstances, this court is not inclined to entertain the instant petition for which the petition stands dismissed. Before parting into the court, this court, however, observes that the dismissal of the instant petition shall not preclude or prejudice the petitioner to approach the competent court of civil jurisdiction as regards the order dated 16/6/2023, if so otherwise permissible under law.
Right.
Yeah, when you
The petitioner was, whatever filing contract was 7 years ago, first of April 21. Well, after that, he started operating. And about 6 months from therefrom, there was a flood of the Becky River and the area where it used to store the sand, that was washed away. Now, it was really allotted some place to store the sand. And then, since there was no formal orders, things from the representation. And they reported, yes, this area is not there. So therefore, there's some area to store the sand in nearby placement. Now, when that matter was pending, and since I was verbally allotted some place to terminate, not terminated. That's that should have been terminated by now. Because the case payment option is disabled. I'm not able to report the case because of that. Because of their blockade of this option, I'm not able to deposit the case, number one. And number two, they have not allowed you alternative land, store the same. These are two issues. Page 60, I had paid my case till first of May, till first of May. Page 60, I made a representation that.
Now, what do you want? Earlier, when you filed some.
Yes, that was closed because the submission was made that I have been terminated, which is not correct. An incorrect submission was made to terminate.
Huh?
An incorrect submission was made by the department that I have been terminated. That's why this honorable court directed me to file a fresh petition challenging the order of termination. And when this order was placed before me, I found that it's not a termination order. That communication lodge will find at page 73, which was alleged to be a termination order. It's not a termination order. They are saying that I am not depositing the case money.
There was a direction to hand over. And there was a routine file by you.
Yes, we drew it, then file this application.
And you have to file a review. And what happened to the review?
Well, review, we withdrew,
Huh?
We withdrew the review petition,
So you have come now,
Yeah.
asking for what?
What's Lordship will see the order at page
You are asking for challenging some order of 8-7.
8-7 as well as 3-5-2026. Annexure 20. 3-5-2026. Annexure 20. Page 84. They are saying that I am not depositing the installment, but then that option is disabled. I cannot. Why? Because this is an online payment. They have disabled the payment option. Is it?
I think I said, but kindly have a look at page.
But why is it going on from 8-7-2025?
Because what had happened, they had
Okay,
issued this
take
super
it by check. Take it by demand draft from me.
Gotcha.
Take it by demand draft from me.
Here's what happens is that since he cannot store his minerals in the allocated area, he asks for some alternative place. Thereafter, the rule 3812 clearly provides a mineral concession holder shall not stock any mineral outside the concession area granted on the mining lease. Thereafter, lawful may take
The doctor's case is simple. He said, "Then look here, I'm willing to pay the money. But you have proved the online.
What? And secondly, my lord, you give me the alternative
Why,
site.
how does the second?
Because
he's looking for alternative site, Lord. He's looking for alternative site.
and that area was washed away by river, flood. Now, unless I'm given a site, to store the sand,
But that will be contrary to the rules.
otherwise, this becomes something, Because what has happened,
That you know it, how do you happen, then you go by the doctrine of substitution.
Fact, when a bidder goes to bid for a particular area, he has to visit that place a lot.
that's why they get rid of this.
The river changed the course when Mr. Doctor's client was there. Didn't it? The river changed the course.
The Beki River, is a violent river, not supposed to be. That's why, they conduct a survey, Circle officers report, Lordship, find page 49, 44, page 49, Sorry, this is another additional deputy commissioner asked if inquiry to be conducted, page 49. 49. With reference to the above, I would like to enclose here the copy of the letter so received from the range officer, Gorpeta,
So regarding permission to stock sand collected in a designated query, land nearby so-and-so, which has been settled in the name of so-and-so. He is requested to conduct an inquiry to matter and take action. Then, my lord, page 51 is a circle of report. To this matter. Page 51, annexure 7. I have the honor to inform you that joint verification was done on so-and-so. In this regard, I would like to inform you that Sri so-and-so contractor is running sand 12 village so-and-so. Wants to stock the sand land covered numbers by tag number so-and-so, which is about 1 kilometer away from the mining site. Because this area was washed
The
away,
application for some other land, why?
because this area was washed away. Wait. Well, page 47 is my application. Because they are fixing go bags there. I given the photographs also.
No, that is not the case of washing away. And you see page 47, what they are using.
Yes, ma'am.
The water resource department is carrying out some work.
Yes, well, because it was washed away, my lord, therefore
No,
go bags are
where is the word washed away?
washed away in the subsequent misrepresentation.
No, again,
It is not there because, my lord, go back fixation is done to prevent erosion, ma'am.
have been settled in the name of me by the forest department for a period of 7 years. Since then, MCA has been operated abiding by the rules and area fixed by the planner. Now, but sir, water resource department has been executing a scheme of geobug fixation on the river bank of the river Becky in my MCA site, for which I could not stop the collected from my MCA in the allotted GPS area. That's why there are sufficient government lands besides the GPS area where I can collect sand, and this is the reason, not washing away, not changing the course.
This pillar was not happily worded, my lord. Subsequently,
What happily worded? Now you want to change everything.
subsequently his representative was saying that because my what should be the photographs also have next.
Where?
Page 46, my lord, section 2.
46.
Yes, ma'am. These are because of the erosion, my lord, these cubics are dump. My lord. That's one of the ways of preventing erosions, ma'am. This geoback scheme is related to this washing away. Though it was not mentioned my lord, that the area has been washed away, but in subsequent representation, the show cause member he has replied that.
Where?
My lord, page 70, my lord, page 65. There are two, my lord. It was flood in the area which was permitted to store the land.
No, kindly come to page 15.
Right.
You say to one platform and put away.
57.
There is no changing of the course. And therefore, if it is so, you knew it when you went out there and saw it. You know that the Becky River has flood. So it is nothing new.
That I did not expect my lord, that this will wash away, my lord. But this, I mean, I cannot.
Everybody knows what the Becky River
So that's true. But I can,
even me sitting out here in Gauhati know what the Becky River does. You are there in the business, you must be knowing
once
it.
it is washed away, my lord, let them provide an alternate site to store the sand. That cannot do that. We cannot do that. We cannot provide an alternate site.
No, they can do only if they have, they bring another area
Right.
within the ambit of the mining.
Yes, but for that, we have to go for another 10 years. We cannot include that. That's it.
So then you have to go for termination, go for doctrine of frustration, whatever. This is not the for page 75.
Here you go. Remember that about unancluded so-and-so, municipal incidents between option number so-and-so, settling photographs on 5, the prohibited so-and-so. Journal deposit royalty and other payments up to fourth quarterly installment, but failure to deposit fifth year, first quarterly installment. The regional cooperative submitted by data memo so it stated that mining contractors who are tasked with extracting the mining mineral outside the GPS coordinates of NTP 50 Itsuka MCA. That the extraction mining mineral was found to be illegal. The same was seized and offense and raised to country from so. In this regard, instead of course, not found is only issued a show cause. The going to Shanuka submitted reply on 23/4/2025 and was found not security. And after that, an order issued for Kamruk and directed deposit the fine and other dues, etc. against the offense. Accordingly, the fine, royalty, etc. was on 17/5/2025 and later issued to deposit the royalty at etc. for fifth year, first quarter installment by data number so and so. Dated 25/2025. After 60 days of the case being due, Shionoga will issue notice and institute the environment suits dated 8/7 asking for reason why his contract is cancelled and will be reduced. I cannot rule 64 your law. Dimension rules is the consequence of illegal unauthorized mine. It says
So
that
now what do you intend to do? Keep challenging some document.
I stored the sand in some other place because the verbally alone. Now they say that was illegally done, but I paid the penalty also.
So you make the payment.
That penalty I paid, paid. Penalty I paid.
No, make the payment as per 3/6.
So that is the difficulty. Something is open to the make it enable the payment of
So your only problem with this, you want to pay.
unless I can deposit my sand, how can I work on them?
Huh?
I cannot work with it. I can extract sand there. And then I can have an area to deposit. What they're trying to say, is they cannot, It's saying that it has to come
Mr.
with the area.
Doctor, Mr. Doctor, what you are submitting, I think you must be instructed wrongly by him. The documents show otherwise. The documents say that once the floods washed away the sand, it is not that they changed the course. It still continued and you are still doing your business. Not that you have not been able to do the work. You say that give me another area, which they cannot. So therefore, it is a case of frustration of the contract if you are not. But the others, no circumstances, there cannot be an extension of the area because these are given on the basis of a mining plan. Mining plan is on the basis of a geographical coordinates. Now, if they extend the area by whatever may be, that would be going against the violation of the Green Tribunal directions and all these things. There are various direction, environmental directions.
DSR also informed. That is the reason they have not communicated us to us that it is not possible. Well, since we did a representation, they will not.
I can do only one thing, Mr. Doctor. I can state it if within 10 days you deposit, you will agree.
Very well.
That's all. Nothing more than that. Nothing more than that if you deposit it. Otherwise, you terminate, you must terminate.
Because it's not that, even if that permission, if it is made.
Now there is no plan.
Now-
Plans have not come. Plans will come in July.
That's
Then we will.
But once the geo bags have been placed there, my lord, I cannot store them. I cannot store
Then
them.
if you are case of, go to the civil court. Best. You go with liberty to go to the civil court.
I think that only, because otherwise, if we pay this amount now, we will not be able to operate. So we have suffer huge losses. But then perhaps 56 is the only option. Frustration. If the loss is done as a liberty, I mean, so far as this, that's the only option. But we have.
To withdraw with liberty to go to the civil court. Mr. M. Dr. Dalani, Senior Counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. R. Gogoi appears on behalf of the Forest Department. The case of the petitioner hearing is that the petitioner was granted a contract settlement for a period of 7 years with effect from 10/5/2021. for annual quantity of 75,000 CUM of sand. Of the NKD-E-15 Mitucha mining wall. It is the case of the petitioner that on account of floods and a scheme being executed by the Water Resource Department of the Government of Assam of geobank fixation on the bank of the river Becky. The petitioner have not been able to store the extracted sand from the mining mine. The petitioner sought for permission to be allotted an area beyond the mining area to store the sand. The forest department, however, have refused to do so, taking into account that the same would be contrary to Rule 38 of the Assam Minor Minerals Concession Rules 2013. The records further revealed that on account of non-payment, steps are being taken by the forest department for termination of the contract. The learned senior counsel appearing on behalf of the petitioner submits that the petitioner is not in a position to make the payment in as much as if the petitioner cannot store the extracted minerals, sand, the petitioner would not be extracted the sand. The petitioner would not be able to use the sand for making a for selling it, for use the sand. The learned senior counsel further submitted that even assuming for argument's sake the petitioner can make the payment, but then also taking into account that the payment has to be made through the online mode and the portal having been, portal is
Portal is open, but the payment on, installment payment option is
the installment payment option have been disabled. And as such, the petitioner is not in the position to make the payment. From a perusal of the above, from a perusal of the facts and the submissions so made by the learned counsel appearing on behalf of the parties, it therefore appears that the petitioner have appeared that on one hand, it is the case of the petitioner that on account of circumstances beyond the control of the petitioner is not being able to extract use the extracted sand. And on the other hand, on account of Rule 38 of the rules of 2013, the Forest Department cannot enlarge the scope of the mining area. So, Mr. M. Dr. Dalal, senior counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to approach the court of competent civil jurisdiction inasmuch as the case involved is a case coming within the ambit of Section 56 of the Indian Contract Act. And as such, the contracts were entered into by and between the petitioner as well as the respondent forest department has to be deemed to be discharged by events beyond the control of the petitioner. He therefore submits that he may be permitted to withdraw the instant writ petition without prejudice to approach the competent court of civil jurisdiction. Taking into account the above, the writ petition stands closed on withdrawal. Liberty, however, the withdrawal of the writ petition shall not prejudice or preclude the petitioner to avail remedies before the court of competent civil jurisdiction if so advised. I've narrated the facts so that it becomes easier. Otherwise, merely just withdrawing, you may not know. Because here you have to go there.
Exactly.
Therefore, I narrated.
Development. The only thing, what used by the storage will be better. Because of the set storage.
No, I have to say that you can't store it, you can't use it. You can't use it. So, Chaudhary, you wanted to obtain instructions?
Accordingly, in the form is there. So we have also narrated in our affidavit in opposition. In paragraph 7, the last 5 years, document. In every case, they have not disclosed the actual death. He was suffering from illness, but that means suffered by the so husband of the petitioner. It's provided. Creation of the legal for the petition to be submitted. The time of
No, you have to be. You say some. Because it
paragraph number 7.
yes, page 31.
Yes. Sir. The proposal.
When did he take up the policy?
uh,
29/12/2010. And the accident was?
Diagnosed. He died due to cardiac arrest. Not died on 14.
14/12/2000. Oh, no, that is understandable. I'm not on that. But the lead is application for HPA from 11/10/2000 AR for self-illness, accident on duty.
11 days, 12 days, lordship, he had taken leave. One is extraordinary leave, and the HPL.
No, we are concerned about the prior to the policy, what is required to be taken.
It is HPL on 11/11/2010 to 25/11/2010.
To 30/11/2010.
11/11/2010 to 25/11/2010.
Kindly come to page 31. This is this internal page 4 of your affidavit.
Yes, Lord. It reveals the truth. The last two paragraphs. From leave record, it is seen that DLA, ABL, POL, and HPL in different dates, many times. Application for HPL from 11/11/2010 to 30/11/2010 for self-illness. Accident or duty. And the another one, the ONGC Limited Assam Asset Building Services, it removes that on 11/11/2010 while drilling well DH, a fatal accident occurred and circumstances greatly affected him. And he went to shot and recover the shot into HPL from it. He did not receive any help. He means the DLA was a known patient of HTM, hypertension. Not on medication, he was admitted to the hospital, fighting to the.
Now, what do you say, Mr. Bora, you have filed some affidavit?
Yes, my lord, I can file the reply, because my lord, there is nothing on record or any evidence to that the prisoner was suffering from hypertension. Because, my lord, the HPAU, paragraph 8, my lord, page 28.
And the policy started on 23/12.
29/12/2010.
No, they say 23/12. 23/12
Yes, date of comment, of
to 14 emails. Now, this is a period of almost how many years? 2 years, more than 2 years. Huh? Then now kindly come to page 60. You say apart from the instances of availing EOL and HPL by the insured or the fact that the insured went into shock without sustaining physical injury due to a fatal accident? What is this fatal accident?
But one of his colleagues was died on the accident. That has been stated in the affidavit of the insurance also, my lord. Just now my friend has said, my lord, he did not receive any physical injury, only affected by the tragic condition of his body. Fatal accident has been stated in the affidavit of the
So he was mentally disturbed on account of the death of someone.
sometime.
But you had, otherwise, neither you had to consult a medical practitioner. Have you been admitted in a hospital or nursing home? No. Have you been, you mean absent from the place of work on ground of health during the last 5 years? No, that is not correct. No, not correct by you. But because at that point of time, you had taken leave from 11/11/2010 to 30/11/2010.
Yes, pilot. It was in shock, pilot, because of the tragic incident of his colleague, pilot. So that's why he was not deep, pilot. But there was no any physical injury or physical health condition for the affected pilot. Kind of death, there. That incident, pilot does not have taken by the incident, pilot. They really find out that he
So you therefore say there is no suppression.
Your final include lordship sees the repudiation order at page 21, my lord. It says simply that. Page 21, my lord. We may, however, state that all these answers were false, and we have evidence and reason to believe that the issued was suffering from hypertension and for which he had taken URL and HDL. All were taken prior to the date of commencement of the policy. So in my petition as well as my reply, I have categorically stated that, my lord, the petitioner was not suffered from any disease of hypertension, and he has not availed any HPR or UL due to suffering from hypertension. Because sometimes he has taken UL or HPL part of invalid unbelief due to suffering from minor elements like cold, in my petition also I have stated category.
So Mr. Chaudhary, we allow
I case design something judgment, judgment of the High Court, my lord. Paragraph 15, 16 and 17 are rules of law.
Anything else? Saying about the protection, there is no limit. But in the reputation of the if there are certain questions which are put to the petitioner, the husband of the petition, in that particular column, the answers in all the questions, the answers are given as no. That means that working absent from place of work on ground of health within the last 5 years. All these things are very relevant when is issuing the insurance. Because of the fact that he was admitted in hospital, although there is no specific evidence to substantiate.
They were not admitted. No, was not admitted in the hospital.
Subsequently, now, with regard to not admission, this a column is there, they will remain absent from placing work on ground of health during the last 5 years. So this in the month of October, you were to leave for around 12 days initially and 10 days subsequently. So this factor is there and this information that has been provided to the court. And it came to the knowledge of the insurance company later on and after the physical demise of the petition. The fact is that this particular information was correctly provided at the time. There was certain clauses which had restricted the insurance company to issue the policy.
Do you have a clause, mental trauma? This is a case of mental trauma.
It was the mental trauma on the first occasion. Subsequently, again, the
No, he took the leave immediately thereafter. He took the leave from 11/10/2020, 2010 to 31/11/2010 to 31/30/11/2010.
11. That was on accident on duty. That was accident on duty.
It was not accident. What is accident? This is a mental trauma.
Yes.
He saw, because he
Also, if the
also say that he did not suffer any physical injury. He did not. He must have been the one taking into account, saw one of his good friends die. No, he died thereafter, after 2.5 years, 2 years, 1 month, 21 days, on account of hypertension. The different thing, he did not take medicines for hypertension. He another. He should have. But he never thought that because of the fact that my wife gets no money, so I don't take the money. And Mr. And then counsel appearing on behalf of petitioners. Mr. S.P. Chaudhary appears on behalf of the respondent number 124. The presence of the taking into account the issue involved, it is the opinion of the court that the presence of the respondent number 4, 5 and 6 are not necessary for the adjudication of the present dispute. Accordingly, the names of the respondent number 5 and 6 are struck off. The petitioners herein are the legal representatives of one Krishna Kumar Bora, bracket since deceased. And are aggrieved by the repudiation of the claim in respect to policy number 444-061-4490, na? 449. 449. By the communication dated 11/3/2015. And under such circumstances, the petitioners have approached this court by filing the present petition. Next. The brief facts which led to the filing of the instant petition are that on 23/12/2010, the predecessor in interest of the petitioners, namely late Krishna Kumar Bora, who was serving as an executive engineer drilling in the Oil and Natural Gas Corporation Limited, Sibsagar, took a policy from the life insurance, the policy of the Life Insurance Corporation of India, which was being policy number 444061449. The commencement of the policy was from 29/12/2010, and the monthly premium to be paid was on 18 was rupees 18, and the monthly premium or yearly premium? Yearly premium.
Yearly.
The yearly premium to be paid was rupees 18,455, which was to be deducted from his salary. The sum assured of the policy was rupees 20 lakhs. On 13/2/2013, late Krishna Kumar Bora suffered from a cardio problem, and immediately he was admitted to the Srimanto Sankodev Hospital and Research Institute, Dibrugarh. He expired on 14/2/2013 on account of cardiorespiratory failure. The wife of late Krishna Kumar Bora submitted the claim forms before the Life Insurance Corporation of India, claiming being as nominee, claiming the amount of rupees 20 lakhs, which was the assured sum. The said claim was rejected by the communication dated 11/3/2015 by the LIC on the ground that the LIC have evidence and reasons to believe that late Krishna Kumar Bora was suffering from hypertension and for which he had taken EOL and HPL prior to the date of commencement of the policy. This aspect was not disclosed. At the time when the policy form was submitted. It was also alleged that late Krishna Kumar Bora had induced the Life Insurance Corporation to issue the policy on a false statement made by him in the proposal statement of the health. And had he disclosed the correct information, the Life Insurance Corporation would not have, of India, would not have accepted the proposal. It is on this ground the claim of the petitioner, of the petitioners were rejected, were repudiated. The petitioner thereupon, the wife of the petitioner thereupon, of late Krishna Kanta Bora thereupon, submitted a legal notice on 11/6/2015. But as there was no steps taken for the redressal, the wife of the petition, late Krishna Bora, filed the present petition in the year 2016. In the meantime, the wife of late Krishna Bora expired, and the petitioners numbers 1.1, 1.2, and 1.3 have been substituted. Pursuant to the filing of the petition, the respondents numbers 1 to 4 have filed their affidavit in opposition. Wherein at paragraph number 7, wherein there is no denial to the fact that the policy was taken by late Krishna Kumar Bora with the commencement date from 23/12/2010 with a sum assured of rupees 20 lakhs, and the wife of late Krishna Kumar Bora was the nominee. At paragraph number 7 of the said affidavit in opposition, further details have been provided as to why the petitioner, the claim in respect to the policy bearing number so and so was repudiated. It was mentioned that in question number 11 of the proposal statement, various questions were put, and all these questions were answered by late Krishna Kanta Bora with the expression with in the negative. It was also mentioned that upon review, upon the claim application being submitted and a review being conducted, it was found that the cause of death was CVA bracket, acute left cerebral hemorrhage with intraventricular extension with subdual collection bracket close. It was also found upon inquiry being made with the ONGC Limited that the late Krishna Kanta Bora, prior to submitting the proposal statement, avail EOL and HPL on different dates many times. For the period from 11/11/2010 to 30/11/2010 for self-illness. It was also found from the certificate issued by the ONGC Limited that on 11/11/2010, while drilling well BGH, a fatal accident occurred on D-E-2000-5, and it greatly affected late Krishna Kanta Bora. And he went into shock, and to recover from shock, he took HPL from 11/11/2010 to 30/11/2010. 2010. It was also mentioned in the certificate which was issued by the ONGC that late Krishna Kanta Bora did not receive any physical injury and only by the tragic condition of his colleague. Further to that, it was mentioned that as per the history sheet of Srimanta Sankardev Hospital, dated 13/2/2013, it revealed that the DLA, that late Krishna Kanta Bora, was a known patient of HTN, not on medication, and he was admitted in the hospital on 13/2/2013, and he was referred by a neurosurgeon, which are HO fall, oblique O fall from bed, for that it's back in drunken state. The record reveals that in pursuance to the said affidavit in opposition so filed, an affidavit in reply was filed by the petitioners. Wherein it was categorically mentioned that the allegation of the respondents that the father of the petitioners suppressed material fact regarding his suffering from hypertension is totally baseless and vague allegation. The father of the petitioner was not suffering from hypertension at the time of purchasing the policy in question. The father of the petitioner, though availed EOL and HPL, however, the same was not availed by the father of the petitioner due to suffering from hypertension or any serious ailment. It was also mentioned that there was nothing on record to show that the father of the petitioner was suffering from hypertension at the time of purchasing the insurance policy in question. The father of the petitioner therefore had not suppressed any material fact in the proposal statement, and as such, due to availing EOL HPL, did not have a correlation with the death of the father of the petitioner. In addition to that, it was mentioned that there was nothing on medical record that the father of the petitioner had suffered from any serious disease or illness prior to the commencement of the policy in question. Merely because the father of the petitioner did not disclose in the proposal form some minor ailment of trivial nature suffered by him temporarily on some occasion, which had no material bearing on the risk undertaken by the LIC or even any remote nexus with the ultimate cause of the death, the same cannot be construed as a fraudulent suppression of material facts so as to permit the LICI to repudiate its liabilities under the contract of insurance. Before trying to make opinion to take note of, this court has heard the learned counsels appearing on behalf of the party and have also perused the materials on record. Mr. So-and-so the learned counsel for the petitioner have laid the emphasis on the judgment of the Ulsa High Court, of the learned division bench of the Ulsa High Court in the case of Anupama Behra and others versus Divisional Manager LIC of India, Cuttack, reported in 2010 to CURCC 111. Yes, it's your time. And specifically referred to paragraph number 15 and 16 of the same judgment. Huh? You want 17. 16. These are the facts. Why do you need 7? That is not law. 15 and 16. This court have heard the learned counsel appearing on behalf of the parties and have taken the material to the court. Of the Insurance Act. The materials and records show that the policy commenced from 23/12/2010 and have been the admitted stand of the respondent LICI. Lake Krishnakanta Vora, who was the insured, expired on 14/2/2013. The stand so taken by the respondent for repudiating the claim of the petitioner, or of repudiating the claim in respect to the policy number so and so, is on account of certain statements being made, certain incorrect statements being made in the statement proposal form. And more particularly in respect to question number 11. This aspect could be seen not only from paragraph number 7 of the affidavit in opposition filed by the respondent numbers 1 to 4, but also from the repudiation letter dated 11/3/2015. The questions in question and the questions which form the basis for the repudiation were paragraph number 2. For repudiation were 18, 8, 11, A1 to 10. the relevant time when the policy was holding the field. And further, at the time when the claim for the policy was made. Section 45 of the Insurance Act 1938 read as follows. It may be relevant to take note of that this section 45, the above quoted section 45, was substituted by the present section 45 with effect from 26/12/2014. From a approval of the above statement about quoted provision, it would be seen that no policy of life insurance effective before the commencement of the Insurance Act 1938 shall, after the expiry of 2 years from the date of commencement of the Act, that show that no policy of life insurance effective after the coming into force of the Insurance Act 1938 shall, after the expiry of 2 years from the date on which it was effective, be called in question by an insurer on the ground of a statement made in the proposal for insurance or in any report of the medical officer or referee or friend of the insured or in any other document leading to the issuance of the policy was incorrect, inaccurate, or false. However, there was an exception. The exception being that the insurer, if the insurer showed that such statement was made on a material matter or suppressed facts which it was material to disclose, and it was fraudulently made by the policy holder, and that the policy holder knew at the time of making it that the statement was false, or that it suppressed facts which was material to disclose. Under applying the said provision to the present dispute, it would be seen that as the policy in question was issued on 23/12/2010, and the insured, that is late Krishnakanta Bora, expired on 14/2/2013, that is after 2 years, 1 month, 21 days. The insurer, that is the LIC, cannot question a statement made in the proposal for insurance unless the LIC shows that such statement was made on a material matter or suppressed fact which had a material to disclose, which it was material to disclose, and it was fraudulently made by the policyholder, and the policyholder knew at the time of making it that the statement was false or that it suppressed facts which it was material to disclose. In the previous segments of the present judgment, this court have already quoted the statement so made in the policy statement by late Krishna Kanta Bora at the time of in the proposal statement by late Krishna Kanta Bora. In order to call in question these statement, the disclosures so made by late Krishna Kanta Bora, after 2 years, it was therefore the requirement of law of the requirement of law that the respondent numbers 1 to 4 is able to establish that such statement was on a material matter or suppressed fact which it was material to disclose, and it was fraudulently made by the policyholder, and the policyholder knew at the time of making the statement was false, or that it suppressed facts which it was material to disclose. In the backdrop of the above, let's see what the respondent number 1 to 4 have found in the inquiry. The said inquiry, what the oh, no, sorry. As will be seen from a perusal of paragraph number 7 of the affidavit in opposition filed by the respondent number 4, 1 to 4. It will show that the petitioner, that late Krishna Kanta Bora had taken EOL and HPL from 11/11/2010 to 30/11/2010. The further inquiries were made on the basis of a certificate issued by the ONGC Limited, dated 10/4/2014, disclosed that late Krishna Kanta Bora was shocked on account of the accident which took place on 11/11/2010, which fatally injured his colleague. It also reveals that late Krishnakanta Bora did not receive any physical injury, but was only affected by tragic condition of his colleague. These materials so placed before this court, in the opinion of this court, would not constitute would not show that there was a non-disclosure by late Krishna Kanta Bora at the time of taking of the policy of a material matter, or that late Krishna Kanta Bora had suppressed facts which was material to disclose. This court at this stage finds it very relevant to take note of the judgment of the learned division bench of the Orissa High Court in the case of Anupama Behera Supra, wherein the learned division bench of the Orissa High Court had dealt with what would constitute material facts for the purpose of non-disclosure. Paragraph number 15 and 16 of the said judgment being relevant is reproduced here in under. This court, from the materials on record, also finds it is of the opinion that not only the LICI had failed to show that there was any fraud committed by late Krishna Kanta Bora in not disclosing a material fact, or late Krishna Kanta Bora had suppressed a material fact, but also the answers to the made in the proposal statement do not appear to be incorrect. The said opinion is based on the fact that late Krishna Kanta Bora expired on account of cardio respiratory failure. And the reason being essential hypertension. There is nothing on record which showed that late Krishna Kanta Bora had hypertension. at the time when the policy was taken. There is also no report placed before this court to show that on account of hypertension, which existed for at least more than 2 years, 1 month, 21 days, the said was the cause of death. Considering the above, it is therefore the opinion of this court that the repudiation so made by the LICI, by the communication dated 15/3/2000, 15/3, na? 11/3/2015, is arbitrary, illegal, as well as unreasonable, and therefore calls for interference. Accordingly, the writ petition therefore stands disposed of with the following observations and directions. The reputation, the communication dated 11/3/2015, thereby repudiating the claim in respect to policy number so and so, stands set aside and quashed. The respondent number 1 to 4 are jointly and severely directed to take appropriate steps for release of the sum amount, assured sum, to the petitioner at the earliest and preferably forthwith and preferably within 3 months, 2 months. What? 4 months is too little.
Because of the pendants of the metal lodgement, you take the confirmation of the.
So what? Are you saying LIC on a claim petition take 4 months? No, I am only questioning it would be it will show very poorly on the LIC comes up everywhere and says that we have a 90% settlement within 30 days. Isn't it? But if I put 4 months and at your request 4 months, it will very much go against the LIC's advertisement. See. Yes, you're leaving. These are documents which were in existence prior to submission of the tender by him. So normally you do it. If the document would have come into, or if it's a rectification done subsequently, it would have been a different case. I would have taken. But otherwise, this is no point taking into account the particular provision which. No, no, no.
Of state. That regard, this two pages, page 28 and page 50. How am I not right to page 50?
Page 28.
First, my lord, page 55. First, should be 99. What should be kindly come to sub group A, sub clause A, 23K. Rectifiable deficiency not corrected within the specified time of 21 days. Now, it is an immediate fact, my lord, that the IUC is not giving any time on the petitioner to rectify the mistake. The reason being, my lord, will kindly come to page 28, page 20.
Yes.
It starts from page 27 minus page 28. The third paragraph.
Yes.
In case it is observed that the lease agreement for the land offered by the provisionally selected candidate does not have a provision to sublease the land. In such cases, the provisionally selected candidate will be provided 21 days time from the date of intimation to so and so. Now 28 and 25 are taken together by humble submission to the power. The aspect of clarification of a lease in the period of 21 days be confined to the aspect of whether the aspect of subletting it by the lessee is present in the lease deed or not. Now, when the documents were uploaded by the petitioner, with or without a mistake, we do not have ascertained the existence of another lease deed with the date within the term of the agreement. And as such, we had done what we had done and rejected the case of the petitioner, stating that his case does not come under one, because the land will be in his possession at a future point in time, and there is no infirmity with the decisions the ROC have taken. Also, the deficiency, correction of deficiency within 21 days would not be applicable in the present matter, because it pertains to changing of the effective date. It pertains to changing of the effective date of the lease. That is my case. That is my case. I have judgment, but as the lordship has pointed out, in this matter, the rectification was done prior, post. But I'll just.
Now, if it is a rectification, keep, just for example, there are many cases which I find wherein applying this clause, they have made submission that these rectifications, another plot of land is being sought to be given. Now, I have held in those cases that no, you cannot apply this for that. Now, if there was a mistake in a sense that particular documents was not given at that point of time, your very terms of the brochure permit these rectifications. Therefore, you say, after finding him to be a group one, good, I've heard many cases, they are all these are all terms are similar. In many cases where Mr. M.K. Chaudhary had also appeared, in these four cases, a particular document was, at that point of time, was not taken into consideration at that point of time. And they have also asked for certain documents to be given later on. Then these documents could not be taken later on because this will change the case at the time of submission. Now, here is a case where there is a mistake in uploading. It's a mistake in uploading. But what happened, you see, the document which was uploaded otherwise remains the same. You see, the first part of the document, the number of the court fee, the number of the document remains the same. Everything remains the same, but only what he had uploaded was the page number 3, which was wrongly sent. It should have been, the page number 3 should have been this document. So this is the thing where it's a rectification which was curable in view of your brochure?
Since the lordship has wanted out loud, my lord, submission of the IC in this regard. Be my lord, subject to your lordship's final opinion.
Because otherwise, how do you give this meaning? Giving 21 days to rectify.
Why not 21 days? Is for rectification of those mistakes which were existence in the fact. If my name is given wrongly, or my significance given wrongly, or my age is given wrongly, existence of my identity is well, then it can be rectified. Now, the moment the IOCL wasn't received of an application by my senior friend's client, where the application itself, time of facing gave a date which is after the last date.
Then you should not have put them in the group one at the first instance.
The structural issue with the.
So therefore, this was the specific question. You should not have done it at that point of time, brought him, and thereby had the lottery with him.
Yes.
You see their application, they categorically mention I fall in group one. What is the lease document, the document on the basis of which you make the particular the assessment out there, you have the lottery, and if he is successful out there, you very well ask him, then kindly provide me. We are going to verify the document after deposit of the 50,000. Here also 50,000, 50,000, and then you say that okay, now we'll verify. At the time of verification, if the document is not found to be proper, then on the basis of that it happens. But here is a case that document existed at that point of time alone. There was no other document. There was a mistake in only uploading the page number 3, which he had made that. So therefore, it is the document which, the fact which existed at that point of time is that is the fact. Any other document on which he has wrongly uploaded, yes, in a tender condition, we look into that. That in a tender condition, all these things will be looked into. But the fact that you given a relaxation of 21 days for making this rectification, and it is not a question of a rectification, he has only given the original, the actual document.
The land is there, the seller is there, the buyer is there, everything is in existence. And 21 days provision is there. I intimated also that I have this document, but they have not accepted it. Page 36 is the provision of field verification credentials. They is their brochure, their route that they can do field verification credentials. They could have asked me to bring the document. I could have provided it. But my case is that I was never provided with a chance.
You see this document which has been given to you does not have the seal which you have uploaded.
The 170 of them, which I wrongly uploaded.
Page 173, page 186. The comments from first day of it.
Does not have the seal. But the page 170. But the document with the circle of the sun, it has the seal in it. They have submitted it before the circle of court to their reply. It is at page 147.
In pursuance to the order passed by this court on 13/5/2026, the learned counsel appearing on behalf of the petitioner, Mr. M.K. Das, has produced the original of the deed of agreement for leave dated 22/9/2023. Uh, This court have duly perused the said document. Taking into account the issue involved, this court fixes the matter tomorrow at 2 p.m. for final disposal. The original document is being returned, be again produced tomorrow. Mr. Sharma, you see one judgment which I have delivered in the case of where Mr. M.K. Chaudhary was appearing. What is this matter? What judgments you are referring?
Particular test of, this is 5 CM.
My judgment?
These are flown from the judgment, of the Kerala High, the Calcutta High Court. There were points which were given 35 marks based on a lease deed matter, which was registered 8/11/2011. But the effective date was when approval would be granted by the IOC. But in this case, as the lordship had rightly pointed out, there was a clarificatory deed registered after the date of the tender. Slightly differentiable from the matter at hand. Paragraph number 2, page number 2. Paragraph number 2, it's a long paragraph, page number 2, my lord. Thereafter, on 12/12/2014. So this is where the facts of that case,
This is different.
the facts are different. So
But therefore, there comes into existence a new document. So if there is a new document, obviously, then it will be changing the rules of the game at a late stage for him. That cannot be permissible. And in fact, you see one judgment which I have delivered of where Mr. M.K. Chaudhary was appearing. Somebody else, I think the repetition was allowed or forgotten, but you just have a look.
my lord, I'll
Because I put a specific question, why you did not notice at the time when you brought these people under the group 1? Because if you bring them under group 1 and you don't look into this very basic thing, this we have seen many cases because of that. I think when they are submitting those documents, you should verify that at that point of time and then select out. Because what happens once he goes out, just for example, if he goes out, again you have a lottery. Because till there is one group 1, you keep on happening, two group 1, you keep on happening.
because he was the only group 1 candidate. Now, to answer your lordship's query, for a moment, I'll just double this code for a minute, my lord. Page 1, the application form, where there is a column which says date of registration of sale deed / gift deed / lease deed / date of mutation / date of notarized affidavit. There, the petitioner, with paid my lord, had put in the date as 22/9/2023. That was the date of registration of the lease deed. And eventually, as I see, my lord, the effective date also, but subsequently they had come into this. So based on this application, he was made as a group 1 candidate. And since he was the,
Because there is also one column where you fall.
yes, group 1,
No, where you fall, that particular thing is mentioned out there.
yes.
So he therefore opted for group 1. So therefore my question, my thing is, why don't you look into this at the prior to issuance of the going for the lottery? In this case, okay, the petitioner was the sole one, it's a different thing. But why? Normally other circumstances also. Because there leads to a lot of litigation because of this. And if you go into that first term, and then one goes, then the second, then you don't keep on, he goes out, then the second one comes in, again there is a lottery. It keeps on happening and thereby the process gets delayed by around 2-3 years.
My senior friend, the BPCL, also agreed that all the oil companies, they have a very different way of going about the selection procedure.
And I know that, I've seen it.
It has word value, then
Mm.
will go and rectify.
Mm.
Then
No,
they-
but this leads to a lot of
It
litigation.
does.
So once you verify those documents at the time of submission, which is normally done in all other tender matters, then the matter ends out there. If you are satisfied and then you don't go for them in group one, then it's a different thing.
At least happened at the first stage itself. Then this litigation might not have issue, but
Tomorrow.
But it is, what you call it, it's like, storage petition. Your petition is because of, non-prosecution.
Why were you not present twice?
Your lordship, at that time, your lordship, I was, about it, where I was off ill. I was ill, a little bit, unwell, your lordship. So, your lordship. At that,
No, there was no representation. How long were you unwell?
last
Unwell,
day.
taking into account that on 25/3/2026 and 4/5/2026, you were not present.
Oh, my, your lordship,
Then what about
Your
25/3?
lordship, that day, your lordship, something, your lordship, I was out of station, that's why I asked someone to represent your lordship. Represent your lordship. But on that day, your
What
lordship,
is your case?
your lordship, it was regarding the grant of an arms license, your lordship.
Arms license.
Your lordship, it was almost at the end stage, your lordship. I had been appearing in the last 2 years, your lordship. You were. I have filed my reply there, filed there with repeating opposition.
Renewal.
Yes, one more.
So your case is that it does not fall under 17.
Yes.
Grounds of 17 does not exist.
My lord, if one case is pending, not charge sheet, and my lord, no antecedent, my lord, trade to his life, my lord. Yeah, paragraph 6 and paragraph 7, what should we have given you?
Mr. So-and-so, the legal counsel appearing on behalf of the applicant, public petitioner, Ms. So-and-so appears on behalf of the respondent. There is an application for recalling the order dated 4/5/2026, by which the accompanying petition was dismissed for non-prosecution. The learned counsel appearing on behalf of the petitioner submits that on behalf of the applicant submits that the petitioner, that the learned counsel was could not appear on that day, taking into account that he was incapacitated on account of his ill health. So taking into account the grounds assigned, the bill and also hearing Ms. Yudas, the learned additional senior government advocate, the opinion of this court that the fit case for restoring the restriction, the recalling the order dated demand 4/5/2026 in the accompanying petition and restoring the WPC number 5481 of 2024 to the file of the court. Accordingly, the instant application stands allowed to WPC number so and so, the order dated 4/5/2026 is recalled, and WPC number 5481 of the 2024 is restored to the file of this court. It's disposed. So next time if you disappear, we have put you, marked you today. In any other case you won't. This is the first time this happened before me, so next time on, be careful. Either you get yourself or ask any of your juniors to be present in every matter for the next 1 year. Okay, let's this matter It is seen that affidavits have been filed on behalf of the parties, taking into account the above. This matter again on 10/6/2026. Mission, an attempt shall be made to dispose of the petition. Survey is not complete. You are appearing. Applied. What are you doing? The council, now you have to change it. This person is now the GMC commissioner.
MD of ACC also.
Huh?
MD of ACC also.
What? Yes. So then. What is this? What are you asking for?
But 90% of work was completed, my lord.
Council and it should be paid within. Mr. Council, this order cannot be complied with.
Lord, I had completed 90% work.
If you are 100%, the fact remains that if you are applying temporarily, there cannot be a disbursement within 5 months. It is impossible. Temporarily's concept is very simple. You put in, find out, verify how much amount is, then put it in the chronological list. Now, do you maintain a chronological list? Discussion and decided to recommend the detail verification against the work. Have you been informed?
Not my,
You have already been paid 25 lakh.
but as per inspection, he has not received any.
What? Huh?
And as per the mind, remaining 24 lakhs 80,000.
Whether it can be done or.
Yes. He signs it.
Total, it was found as 50 lakhs 80,000. You pay that amount of 25 lakhs, as
No.
you had found out.
25 out of 20, remaining 25 lakhs, not so. 11, 2 lakhs they have paid and this amount and they will pay 2 lakhs per month for 1 year. Within one year, they will pay the remaining amount.
Put it on affidavit.
That's it.
Put it on. The respondent is represented by Ms. So and so. It has been mentioned that though the petitioner claimed an amount of rupees 94,87,012 for the work pertaining to the improvement of station building at Bukakhat. However, upon actual measurement being carried out, it was found that the petitioner's entitlement was rupees 50 lakhs 80,309. It is further mentioned that out of the said amount, 25 lakhs have already been paid to the petitioner. Hence, as on 6/5/2026, an amount of rupees 25 lakhs 80,309 was pending. In addition to that, an amount of 2 lakhs have already been paid to the petitioner by the check bearing number 199514. It is also the decision taken in the minutes of the meeting dated 6/5/2026, that the remaining amount of rupees 23 lakhs 80,309 shall be paid in installments within a passage of 1 year. It is the opinion of this court that the said aspect be brought on record by way of an affidavit, so the appropriate directions can be passed. The instructions of place, the minutes of the meeting held on 6/5/2026 is kept on record and marked with the letter H. Yes, what is this?
Wait, please, Your Lordship. Lordship, this is the petition for restoration of WPC number 6958.
Oh, that day I
the
want
delay-
to dismiss your case, na?
Lordship,
There is no industrial disputes. What is the? Is a delay also.
Lordship, delay. There is a delay.
And restoration.
Restoration.
And the matter of here is challenging an order dated
Order dated 39/2014.
passing exporting no dispute award and the reference is good. And it's a 14 order. The pay- What you mean? You know, industrial dispute.
Lordship, as per my instruction, Lordship, the out of 64 demands, only out of 64 demands of the charter of demands, only if demand number 2 and 12 is implemented, then they will be benefited, all as are the pension holder. So they will be benefited in
What?
to formulation of waste structure exclusive for the CC.
Here they are by creating the demand. By
So page number 28.
So the jubilee benefit. They could not show the- Which are these?
Page number 28, Lordship.
28.
28 of this writ petition, Lordship.
Which one?
Two, number 2.
Population of waste
Wage.
structure exclusive for the CIM.
And Lordship,
How can that be? You people are no longer in service. What wage structure? It was given in 89.
Lordship,
85. 89.
89.
89. Reference was made in the year 2000.
Reference was made in 91, Lordship.
91.
Lordship.
We are in 2026.
Lordship.
What do you mean?
Lordship, see page 28, the charter of demands placed on 31/12/85.
No, it's okay. The based on realistic building and should be good. So what do you mean?
And now there is asking for number 2, already waste structure has been done, all are in IDFA pattern scale right now. These are the 2
And Lordship, 12. Lordship.
There's no industrial dispute in it. It's one thing, we restore it and close it, there's no industrial dispute. There has to be an industrial dispute, you know. We are concerned about 30, 26, and plus another 9. That is 35. 35 years from the date notification was made. In respect of a dispute which is 38 years old. In respect to a demand which is 42 years old. We condone this and dismiss it. I contribute. Is an application for condoning the delay of 29 days in filing the accompanying application for restoration of the writ petition which was dismissed for default by an order dated 22/10/2025. Taking into account the reasons were assigned and there being no objection from the respondents, this court condones the delay of 29 days in preparing the accompanying application for restoration of the writ petition which was dismissed for default by the order dated 22/10/25. I stands allowed. This case number so and so. This is an application for restoration of the accompanying writ petition being WPC number 6958 of the 2026, whereby the writ petition was dismissed for non-prosecution by the order dated 22/10/2025. This court have heard the learned counsels have given the materials, the amendments made in the instant application. It also heard the learned counsels appearing on behalf of the parties. Taking into account the reasons which have been assigned, it is the opinion of this court that this is a fit case for recalling the order dated 22/10/2025, by which the accompanying writ petition being WPC number 6958 of the 2016 was dismissed for recall. Accordingly, the order dated 22/10/2025 stands recall, and the writ petition being WPC number 6958 of the 2016 is restored back to the file of this court. I stands disposed. This case stands disposed. Therefore, main heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Union of India. Mr. S.S. Roy appears on behalf of the respondent number 1. Ms. Udas appears for the respondent number 2. And Mr. J. Roy, the senior counsel assisted by so-and-so appears for the respondent number 3. This is an application filed by the present petition has been filed by the petitioner. By the petitioner challenging the award dated
The lending the award is
39/2014. Challenging the award dated. Where's the award?
The award is lordship reference case, award is lordship
Challenging the award dated
6413. 6413 is the reference case number, reference case order.
the award dated 6/4/2013, passing reference case number 17 of the 91. As well as the order dated 13/9/2014, passed in Miss case number 1 of the 2014 by the Learned Industrial Tribunal, Gauhati. This court duly takes note of that on 6th of December 1991, a notification was issued by the appropriate government, thereby making a reference to the presiding officer of the Industrial Tribunal Gauhati, the following terms of reference as mentioned in the schedule to the said notification dated 6/12/1991. The terms of reference mentioned in the schedule are mentioned below. Page 56. The report revealed that by an audit that pursuant to the said notification being issued, a reference proceedings was registered, being reference case number 17 of 1991 before the Industrial Tribunal at Gauhati. In the said proceeding, both sides participated initially. The said reference proceeding, after 23 years, was closed by an order dated 6/4/2013. On the ground that neither of the parties were interested in the said proceedings. There was no steps so taken in spite of specific directions passed by the learned tribunal, by the learned industrial tribunal. It is under such circumstances that the learned tribunal came to an opinion that there was no industrial dispute which was there in existence between the parties. And under such circumstances, a no dispute award was passed. The report further revealed that the petitioner thereupon filed an application before the Learned Industrial Tribunal, being Miss Case number 1 of 2014. And thereby to recall the order dated 6/4/2013. The Learned Industrial Tribunal, by the detailed order dated 13/9/2014, observed that there was no sufficient cause for recalling the order dated 6/4/2013. And accordingly, the said application was dismissed. The present petition has been filed. The 2 years thereafter, on 15/11/2016, the present petition was filed. The records further revealed that this court had issued notice the records also show that twice, the petition was also dismissed for non-prosecution. In the backdrop of the above, the most pertinent question arises in the present proceeding is as to whether there is any industrial dispute which is in existence, or the said dispute has become stale over the passage of years. It's very pertinent to observe that the terms of reference which has been mentioned in the schedule to the notification dated 6th of December 1991 was primarily in respect to two aspects. The first is pertaining to whether the action of the Bukazan Cement Corporation Employees Union in raising demands by the letter dated 21st/24th July 1989 before the general manager Bukazan Cement Factory, Bukazan was justified. The charter of this court have also perused the charter of demands. Which were submitted in the year 1985.
Right.
1989.
89, Lordship, but the charter.
Year 1989.
85.
These demands were made in the year almost 37 years ago. And the same demands as on date no longer have as on the no longer would have relevance, taking into account the passage of time. Under such circumstances, the said terms of reference pertaining to the raising of demands on the basis of the charter, on the basis of the letter dated 21st of the 24th July 1989, had become a stale dispute. The second aspect in the terms of reference pertains to the strikes resorted by the workmen of the cement factory on 23/4/1991 to 24/4/1994 to be legal as to whether to be legal and justified. The same aspect also had become stale over the years, taking into account that 35 years have passed by. Under such circumstances, it is the opinion of this court that no meaningful result would occur, would arise. In the circumstance that the impugn award dated 6/4/2013 or the order dated 30/1/2014 is interfered with. Accordingly, this court does not find any merit in the present petition for which the petition stands dismissed. Before parting with the report, it is observed that the dismissal of the instant petition is on account of the demand becoming stale and therefore there being no industrial dispute. The said reasons for which the instant petition has been dismissed shall not preclude the petitioner from a trade union. You're a trade union, employee union. Yes, it's a trade union or what?
It is an Bukadan Cement Corporation Employees Union.
It's a trade union. The petitioner union to raise any such demands permissible. And the notes and the observations made in the present judgment as well as by the learned labor court of passing a no dispute award shall not affect the petitioner union to say to raise such disputes if otherwise permissible.
If you This 17 of that one, because this was my first case in the professional life. Right? It was the first case in my professional life when I joined 17 of 19.
Deeply of light. Could we put that it is so stale that the person who joined has become a senior advocate, that's a very senior advocate. What is this?
Lordship, as per the laws in our court's order, Lordship, 11/5/2026, that is complete with respect to respond number 3, Lordship. And agreeing for 1, 2, and 3.
Service being complete. What is this? That pertains to?
Lordship, some fraudulent transactions were taken place, Lordship, for which amount was in gold, Lordship.
What has happened to you now?
The amount that has been not been released by the bank, Lordship.
How much?
Lordship, total amount about around 1 lakh. No, around,
Dispute amount is 49,674.4 as per the Sagar crime mail.
two petitioners are there, Lordship. Two amounts are there,
Petitioner, different persons
different persons,
for different accounts
for different account, Lordship.
and one requisition,
Lordship,
not position.
Lordship, because
No, then why do you go and go to the streets and cancel the any person who has any grievance against Union Bank of India? Any- And also join the state bank also and all the other banks also. This type of litigation.
no, Lordship, cyber complaint was Lordship. Initially, the amount was deposited in the bank account of petition number 1, Lordship. Subsequently, from petition number 1, the account, the payment was made in the account of the petition number 2,
39,000.
39,000.
And your number one amount is 49 lakhs.
49,000, Lordship.
No,
Yes, Lordship.
yes, there are two amounts.
Two amount, Lordship.
One is 49 lakhs,
No, Lordship.
64.
49,000, Lordship.
Further, we direct the respondents not to release the amount of rupees so and so and so and so to the account of the respondent. Now, who deposited this amount?
Lordship, some unknown persons deposited an amount. Initially, Lordship, the husband of the petitioner number 1 is a bank correspondent, Lordship. He gave financial assistance to the nephews, to his nephews, Lordship. Subsequently, the nephews returned the amount, Lordship, but through some unknown person's account. That were tagged as fraudulent, Lordship. Not the entire amount, total 65,000 was returned, Lordship, out of which 49,000 something amount was disputed amount. And the petition number 2, he came with an amount of 50,000 to the petition number 1 to be deposited in cash.
50, you want to file a review? Yes. The survey is being complete. List this matter again on 19th of June 2026. Liberty given to the respondents to bring on record their stand by filing their affidavits on or before 15th of June.
Annexure 9 of their petition. There is an order passed by ACGM, ACG Senior Division Court. Ghaziabad. They have taken, they have asked the bank to release them.
Yes, that is why
To the respond number 5.
Respond.
Do whatever you feel like. There's no stay. Here's the voter.
This case, the order has been complied with. Here's the T has been removed.
Order complied is different. We are not on complied with. He was not permitted to vote in this last election. Isn't it?
Yes, Lordship, and even all ration card is not issued because voter ID is not there. So this is the reason it's all the beneficial schemes of the government,
Very
she,
serious.
yes, Lordship, even she's in widow that she is entitled under another
We
scheme.
do.
Yes, Lordship.
We do.
And in the interim there also. we pay. I leave up to that.
This order you should have got it, madam, on the first day. I would have, if I was the person before whom you would have seen the material plan, that's remove the law.
So this is the total, so March,
Which unknown person?
no, simple.
Sinha is
Name
the-
is what? Unknown Sinha.
Sinha.
Here you have mentioned Singh. You may again say later on the another person. Or never.
Epic number is same. Epic number is same.
In the voters
I
list,
will put it wrongly. Unknown Sinha.
Because in the epic electoral roll, the name is Ananta Singh.
Why for?
And
Why?
in Assamese it is Ananta Singh. Wife of
How do you sing ho? Sing ho. Ho is there, but
the what?
in
The electoral, it has been removed. But it has been brought to the attention of the court that the petitioner name has been removed. The D mark against the petitioner's name in the electoral roll have been removed by the speaking order passed by the electoral registration officer 37 Jalukbari LEC on 11/5/2026. In addition to that, the B mark in the ECI net in the portal in the ECI portal against the petitioner's name have also been removed. In that regard, the snap screenshot what the screenshot of the portal is a screenshot of the said portal have been provided before this court. Both are collectively marked and kept on record with the letter X. Taking into account the above, nothing further remains in the instant repetition of which the repetition stands closed. What is this?
The matter
More steps have been received by the section till today upon response by 11.
that has come erroneously, Lordship. Actually, there are only 10 respondents, Lordship.
Oh,
In
then why they have mentioned that?
actually, Lordship, in order dated 8/4/2026, Lordship, it has been wrongly recorded as 6/11, Lordship, para number 7, Lordship. Yeah.
This court had really perused the writ petition. And from a perusal of the writ petition, there are only 10 respondents. Under such circumstances, the question of taking steps against the respondent number 11 does not arise. The rest we shall take note of the above and do the needful. List the matter upon service being complete upon all the respondents. Well, order 6. It is an application filed for treatment of the opposite parties numbers 1, 2, and 3. 1, 2, 3, 4. 1, 2, 3, 4.
No, that's only one, Lord.
Then why are you making all the other people opposite parties? Only one lot.
Opposite number party number one.
Ankita and Anamika Tiwari lot.
The respondent number five in the accompanying issue, accompanying contempt application. It is the opinion of this court that the presence of the opposite party number one, present application would be necessary for effecting compliance to the judgment and order dated to the order dated 2/12/2024, passed in deputation number 4728 of 2024. Accordingly, the opposite party number one is impeded with the contender number five with the accompanying contempt application. Learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the fresh memo of parties as well as the present order, make necessary corrections in the course title or the accompanying contempt application and update the same in the CIS. IS stands disposed of. Respondent number five, issue notice upon the main petition. Issue notice upon the newly impeded respondent number five, or contender number five, steps be taken by way of speed post within 3 days. The instant contempt application is returnable on 25th of June 2026. Hello. So and so appears for the respond number 1 and 4. Why it has not yet been complied with? Hello. Yes, Mr. Doctor. Next, the matter about, it's a matter of reinstatement without activities. Modifying the award. Yes. What award has passed? Now, the award you lordship will find at page 42, the operative part will be taken into motion. What do you want? The lordship can you see, main point from there I will speak. Not only thing about the legal question of B. In terms of section 33(1)(b), the investor dispute act. Now, if they want to dismiss me, then it's a mandatory provision, but they're required to file an application before the conciliatory authority. Where the similar matter is pending. Look, in regard to my substantial allowance, they did not pay. So my lord went there, find the miscellaneous application, and then they passed an order to pay 75% of the subsistence allowance, which was not given by the money. And in that order, the conciliatory authority has passed an order that if you want to dismiss, that should be with the permission of the author. Now that will also find. No, wait. Can you come to page 42? 42, yes. Well, in the middle part, I'll take your lordship. Main point to be decided. So come to the last 4 lines of that. Yes. So I am of the opinion from there that the domestic inquiry was not conducted properly as management had issued penalty order against the workman on the basis of its party and inquiry report, but as inquiry was not conducted properly, the order passed by management on 30/3/2025 for termination of some so is set aside. Management side is directed to restore the service of the workman named so and so without any backwards. Management side is directed to examine the penalty that is imposed upon the workman. So in terms of that, the petitioner joined the organization, then after a few months left. So only consideration of which are not to be here, whether the back wages for 1.5 years can be given. That is the only, because since he has in the meantime left the organization, there was no other.
So you have reinstated him.
He joined, then after 4 or 5 months, he left the organization. So therefore, even if you also look at section 33, that is said it's a deeming provision, even the reinstatement order is not required to be passed.
Now, my question is, if you have not relied on the award, inquiry report, how the tribunal could have come to a finding without giving you an opportunity for adducing evidence? You adduce evidence.
Yes, and the industrial tribunal will give an our evidence. Yes, we have.
You have adduced evidence, then he has to discuss the evidence.
He did not work, he has discussed. But
No,
then,
no, no. He's why? From not maintaining so and so, so the aforesaid reference is liable to be dismissed and so and so. None of counted, these are all submission.
yes,
So here he has decided, inquiry officer, he says that the inquiry report is bad. The moment the inquiry bad, then isn't it required for him to go into the evidence led by the management?
yes, the industrial tribunal, whatever the evidence was given, it was incumbent upon him to discuss all.
He has not done so.
He discussed, but then not exactly.
No, when
Even without going into all this.
inquiry officer holds that the inquiry via charges brought against the are duly proved. But he is only into this inquiry evidence.
Your lordship will find is a huge one, and discussion is not only a very
No, he is only into the inquiry.
inquiry, my lord, that is the fault on his part. But he has discussed the evidence.
No, where is here?
His finding is not in terms of the discussion what he did. As if he was looking to the other side. Supposed to be present, then
Records are available.
counsel, Mr. Leroy called me a few days back that the director is expired in the meantime. My lord, he expired also, some other director is there. Therefore, then the question of getting the department.
What like?
Director of this tea state, my lord. So possibly he thought shall be paying for treatment of the party. Your lordship, can we see, the point number 1. The management of money private state represent by
Management is in continuity in yes, the opportunity, so there is no requirement.
no requirement. But possibly it was playing in his mind that we might fell in a. But that's not necessary.
But why did you reinstate him? That means you accepted that award.
A reinstatement was made, and even if it is reinstatement, my lord, your lordship, can we see if we look at section 33 of the industry? On that short aspect, my lord, possibly your lordship will be wrong. Section 33 of the industrial dispute.
But other side is not there.
Also, is not there, that is then. Your lordship will take some other date. 33(1). I just read, my lord. Conditions of service, etc., to remain unchanged in the certain circumstances during pendency of proceeding. During the pendency of any conciliation proceeding before a conciliation officer or a board, or of any proceeding before an arbitrator, or a labor court or tribunal or national tribunal in respect of an industrial dispute,
no employer shall, we come under A, my lord, in regard to any matter connected with the dispute, alter to the previous, we are not on A, when we are on B. For any misconduct connected with the dispute, discharge or punish, whether by dismissal or otherwise, any workman concerned in such dispute, save with the express permission in writing of the authority before which the proceeding is pending. Now, the proceeding was pending before the conciliatory authority in regard to its subsistence fellow. The order was passed, pay 75% to subsistence. That was not paid. And even in the judgment, my lord, at page 31, you will find that. Page 32, maybe. Start with 31, and you also can see 32. Petitioner's further case is that Assistant Labor Commissioner Shilchar, by this letter dated 7/2/2004, had issued an order for immediate payment of various subsistence allowance up to date with 75% and the provision of Industrial Dispute Act. But the management side, in spite of receiving the copy of the order of Assistant Labor Commissioner, had issued a letter dated so and so, directing the manager of the Maniknagar estate not to discharge the dispute of workman without prior express permission from his office. So therefore, in terms of 33(1)(b, it is incumbent on the authority, they will have to take permission from the conciliatory authority. Without that permission, they cannot dismiss. So this is the mandatory violation, by because the compliance of 30.
Very meaningful.
Yes, yes. The management.
Oh, you are for the workman.
No, I am for the workmen, but they did not comply 33(1). Possibly lawsuit for the many.
You look like a management lawyer. They may expect Mr. Da.
No, that's the nicety of this profession. Sometimes it's
That's why I'm getting confused. What the hell? Why you are making that submission?
when the lawsuit was posing the question, I thought the lawsuit told me.
But this award is wrong. This award is wrong. You have to set aside this award.
That is what I. But then they did not come
In
up.
fact, the learned tribunal ought to have looked into it. You had ought to have gone into further and looked into the evidence and discussed and passed.
Yes, discussed, the lawsuit will fine.
Understood, but there is no finding on the basis of the evidence.
Finding is something else.
So how do you tackle with this thing?
Yes,
This
it
is a
was
case where
appreciating.
both the parties should be directed to appear.
But then, my lord, I thought the matter has already been, is over in the sense because after instatement he joined, then after 4 months he left the job. Then my
So
lord,
therefore you are making the submission. The only question is as regards the equity.
exactly, but otherwise there is no point of sending that also.
No, fact remains that there is no discussion.
Yes, that discussion is there, but he could not come to the finding.
But how do you give it? So he should have come up to the finding in the basis of evidence. So when you are there, we can very well dismiss your reputation. I can't allow your reputation. He should have challenged it.
We ought to actually.
Why you are challenging me? I don't understand. When there is a direction to restore the barrier, the so and so. No, why you are challenging the import?
We are telling you there is backwages. We have come for that only.
Without backwages.
Without back.
Rightly so.
Well, but then if the lawsuit look at 33, well, Lord, what the appeals court is saying, can I take a look? Just one paragraph.
Okay, let the other side come. It's a very serious thing. But it's the other way around. Why they have not challenged it?
I was thinking, I did not put it. And the backward is also will be a niggard, not much.
How much?
1 year, 6 months, it could be around. More or less 1 month.
None has appeared on behalf of the respondent on call. However, for the ends of justice, the matter stands adjourned to be listed again on June 11th of June 2026. It is observed that if the respondent is not represented, this court shall proceed with the disposal of the writ petition. Taking into account that the writ petition has been already pending for a decade. Now, this time also he has not appeared. None appears on behalf of the petitioner on call. It is also seen that on 24/4/2026, none has appeared on behalf of the petitioner. From the above, it therefore appears that the petitioner must have lost interest in the instant proceedings. Accordingly, the writ petition stands dismissed for non-prosecution. Mr. G. Goswami appeared for the railway department.
Okay.
How is your petition maintainable?
My lord,
Your fighting we did with against, you want the money from them. Oh, file before the civil court. Why? Writ petition.
my lord, that email and I email, the subcontracting was allowed.
So what? Was the authority, if the authority allow you, recognize you as a
My
sub,
lord, the due information and permission of the authority, the contractor, the petitioner has worked to the contract.
where is the document?
Document, the main agreement, my lord, they retained with by the respondent number 8.
Sorry, go for this. This court is not going to end
That department, we submitted the representation before the authority, stating everything. That was also not, my lord, attended.
Can't help you. You have some disputes against him, you do it whatever it is. As regards this, and not only one, many. Urban, Dibrugarh, Atal, Mission, everybody. If you have any, you must be doing a subcontractor of the
Under the respondent number 8.
Hmm?
Under the respondent number 8.
So, it's a private dispute between you and him. Go there. I hope. The present deputy heard Mr. P.J. Sarkar.
But my lord, may have placed one judgment of another court again. May have placed my, that my lord, the right of the subcontractor has been not only recognized, but relief was also granted.
By,
My lord,
by this court.
by Justice, my lord. Justice Sanjay Kumar. Sanjay Kumar.
Show me.
Almost similar to this case, my lord. But only the difference is, my lord, that the petitioner was registered under MSNE.
Oh. They have a concept. What is different? With NHI, NHI, PCS, they have an option by which they are recorded.
Here in the case also, my lord, the general condition of contract, my lord, clause 73, my lord, recognizes the subcontract.
Good. For you, therefore, to go before the civil court. Urge Mr. P.J. Sarkar, the learned counsel appearing on behalf of the petitioner. Mr. Buddha appears on behalf of the respondent number 1, 6, and 7.
Mr. HK, the service owner, appears on behalf of the respondent for 8 and 9. The petitioner herein has approached this court seeking a direction upon the respondents to pay an amount of rupees 2 lakh crores, 4 lakh 39,298, which the say which is due to the petitioner from the respondent number 8 on account of works on conduct carried out by the petitioner as a subcontractor for the respondent number 8 in respect to the works but done under the respondent number 2, 3, and 4. The above was this court had really perused the materials on report. And from a perusal of the materials on report, it is seen that the dispute in question is a private dispute between the petitioner and the respondent number 8. And under such circumstances, it is the opinion of this court that the public law remedy cannot be initiated for such resolution of disputes. Considering the above, this court is not inclined to entertain the instant petition for which the petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant petition shall not preclude or prejudice the petitioner to approach the appropriate forum seeking relief against the respondent number 8. Further to that, this court also takes note of that the petitioner have been bona fidely litigating in the present proceedings on a with believing that that this court may entertain the instant petition. Considering the above, this court observes that the period from 5/4/2022 till date be excluded while completing the period of limitation in preparing any claim against the respondent number 8 if so advised. Government have to, municipal court has no file with it. What is your instruction? You're not highly affidavit. Are not interested.
Remission. That is claiming remission
Of has he deposited the amount? No.
No.
You have not deposited.
Not
Mr. Counsel. But the petitioner has been directed to, in order by which the petitioner has been directed being privacy without any reason to state 10 lakhs. Accordingly, it states 10 lakhs.
it was state by this one. It was state, we have claimed, but he has not. It was state by the law. It includes this literal document whereby we have claimed the remission amount. We have given remission of 25%. He is claiming 100% remission back. The he is not yet.
So there is a direction to pay like 10 lakhs.
We have claimed 10 lakhs from
I
his.
have stated. Now, you don't want to file a reply. But the interim order has thereafter been not extended, not.
Kindly interim extended.
What? Why didn't you ask the other court to do it?
Municipal court again and again.
I received the respondents in spite of interim order passed by this court on 15/12/2025. Have not cared to file any affidavit till date. Considering the above, this court grants a final opportunity to the respondents to bring on record their stand by filing the affidavit. So accordingly, list this matter on 14th of August 2026. Final liberty given to the respondents to file the affidavit on a final opportunity being given to the respondents to bring on record their stand by filing the affidavit on or before 5th of August 2026. Interim order passed earlier on 15/12/2025 stands extended till the next day.
There's an IA as well. The IA was filed for impediment of party respondent number 5. That was felt necessity.
Implead whom?
The landlord, your lordship,
Why?
on lordship. Respondent number 5.
What is the matter about?
The matter pertains to your lordship, trade license. The municipal authorities have refused to. My husband used to hold the trade license, your lordship. After.
I
his death-
remember.
Yes, sir. We have given in the, we have renewed it so that he can maintain the shop. But the landlord is objecting like anything. There is no agreement. They are not doing it. He has dismantled the house. That is the problem. That's why landlord has been called.
As on date, your lordship, the trade license is in the name of the deceased husband. They have renewed in the name of the deceased person. The municipal authorities.
Landlord is objecting.
Yes.
Mr. Mukherjee, why can't we apply taking into account the judgment of the Supreme Court in the case of essential service that electricity matter immediate, deleted. This is your livelihood. So therefore, for the purpose that an objection has been filed, why we cannot direct the area to give it immunity, thereby dispense with the requirement? Because he's here, he's or her livelihood. Yes. So therefore, you cannot continue in the name of so and so. So therefore, why can't we do that instead of making her a party and
In fact, I have filed a separate application to grant it in my own name as well. I have brought it on record, your lordship.
but the only thing is, it will open up a Pandora's box. So not a Pandora's box, it will open a floodgate. Don't you think? With this order being passed, it will open up floodgates with all tenants not asking for.
But I have got no objection to it.
You have no objection, but the thing
The
is,
tenant is rejecting, there is no agreement. They said you must do it some agreement.
he is, after all, if there is no agreement out there, then if they need to hear, he will be obviously a tenant by sufferance. If he is a tenant by sufferance, he will continue till he is being evicted by law. So by that way, the trade license which is there is an essential part of carrying on the business. So the livelihood is being taken away at the behest of a third party. Can it be done by the state?
That's why my honorable court directed to impede the landlord That what is the opinion of landlord?
Opinion of there's an order by that.
Okay, in fact, I sought the indulgence to dealings, but on 23/4/26. Liberty was granted to.
Or they will let him come and say, my lord, probably it can be solved out.
No, there's no direction as
There's no
such. I think the best way out is passing an order to the defendant. Or you want to cheat? You want to cheat? That will be-
If it will prolong the matter further, if I implead, we will get an opportunity to respond as well. There's a civil litigation as well going on.
Civil dispute is going on.
Therefore, more the,
Landlord and the tenant.
the more, because of the civil suit also, obviously they are not. Now, I still remember the judgment of Justice Manishana Singh. If we apply that principle also, Justice Manishana Singh say that there is no requirement of tendering the rent again to the landlord, because as per section 5(4), you are required to tender the rent every month. When there is a bad blood, so therefore, when there is already a civil suit pending as regards eviction and all, no point of that they are going to give in. The moment they give it, they will be doing it to against the prejudice to their rights. So they be to prejudice them. So therefore, it's not important. Hello, let us dispose it of on Thursday. Look here, dispose it of. It's this matter on Thursday for the 2 people. Yo, Mr. Mukherjee, provided you bring that, that is money, you not think that I have it in my book, but then we use it. Well, yes, where is the counsel appearing for the petitioner? And what is, huh? I see. They appearing for? I see. Now, I say let's file affidavit. After filing of the affidavit, the counsel for the petitioner ran away. And they are filing the minute with the petition, they have to file a reply against. No, madam. Huh? You have filed, not filed, madam, we filed. You want to file. The counsel appearing on behalf of the IOC and submits that an amended petition was filed on 18th of September 2024. And the respondent would like to, respondent IOC would like to file a reply affidavit, an additional affidavit in opposition. Taking into account the above, this matter came on 17th of August 2026. In the meantime, the respondent IOC is given the final liberty to bring on record their stand by filing the affidavit on or before 13th of August 2026.
I just point of the non-payment of contractual.
Non-payment. But why no payment has been given, Mr. Denia?
As per your order.
Which department?
The water resource department. my lord. Already, my lord, the water resource communicated to the Federal officer, my lord, reflects on the order dated 1911.
What is happening now?
Russian paragraph which has been taken to stand on paragraph number 6 months. Because of non-furnishing of bank guarantee. Because of non-furnishing of bank guarantee as per direction, it could not be processed and subsequent.
Bank guarantee?
The-
Madam, have you been to a bank to get a bank guarantee? If he for 4,25,000, he wants to get a bank guarantee from the bank, he has to deposit 4,25,000, then they will give you a bank guarantee.
What's the time?
Ask for an indemnity. What is this bank guarantee? will be?
Like, your lordship order on 1911, my lord. On 2025, my lord, and paragraph 5, my lord. There is observation to take steps for leading the my lord.
Say that benefit that the letter has been written to the president 23. So the amount was not paid to Mr. R.K. Das. So therefore, why the petitioner should not get the money? So then, so there was a specific direction that the respondent may take steps for releasing the amount upon crediting the amount to the head of the account. After this, why this has gone? The specific direction being passed by this court.
It will come after 2 weeks, you will take instruction on this.
Friday.
Because
No, Friday. Because there is a complete non-compliance to the order dated for the last 8 months. Didn't it?
24.
Line. Madam, see, paragraph 3 of my order dated 1911. It is also seen from the said affidavit that the letter has been written to the treasury officer Subsagar to credit the amount to the new head of the account by communication dated 31/10/2025. Taking into account the above leaves the matter on 21/1/2003. In the meantime, the respondent may take steps for releasing the amount to the petitioner upon crediting the amount to the head of the account. Then
get the instructions.
now the petitioner has been troubled to make the finance department, the treasury officer parties. Then they have also implement, all these things are going on. With 4,25,000, how much torture are you going to met out to upon the petition? Tell me.
Get my instructions.
Friday. Full stop. Ms. P. Chakraborty appears on behalf of the Water Resource Department and submits that she would obtain instruction as to what steps have been taken in pursuance to the order passed by this court on 27/10/2025 and 19/11/2025, respectively. Full stop. List this matter again on Friday.
Please, your lordship.
Yes.
In this case, the respondent number 1 was directed to file their affidavit.
Who is respondent number 1?
My lord, the certificate, lordship will see the last order, my lord. There was a direction that, my lord, this issue will be resolved by the chief secretary and my lord, report will be furnished. Regarding a settlement of a part.
Appeals for APDCL.
Yes.
You? Today there was one matter. Item number. You were not there. I was not marked with that matter. I'm not going to get yourself marked. Get your instructions in the matter. We are having it on Wednesday. It's a very important matter because there is a question they are asking for stay. Get it there. Otherwise, we don't like just right on the corner, that particular part which is leaving in operation. Yes, what is it?
Yes, my lord, the lordship will see the last order. Regarding settlement of a part. Which between, yes, my lord, the issue involved in the.
This part also,
Same thing.
same part?
No, not same, the issue is aware criminal.
PDCL, you have been creating problems with giving rights to everybody. And now it is being given by somebody else.
So, my lord, the date will be now fixed, my lord. Today I have talked to the authorities, my lord. Where, my lord, all the 3 parties will be called and a decision will be taken, my lord. I pray for some time and it will be resolved and I will file the.
Three parties means?
Petitioner, ATDCL and 1, my lord, society of where the deputy commissioner is the chairman. So there is a dispute between 3. It was settled in the name of the petitioner.
Earlier.
Yes, earlier.
Then
By
you meet the
ATDCL.
part.
Now, my lord, district authorities are claiming that, my lord, their
particular part of the part will be controlled by them. It will not be given fully to the petitioner. Whereas the tender says, my lord, that it will be fully operational by the highest bidder. So now there is a dispute, my lord. He has not been able to operate. So Honorable Court said that since the chief secretary is the party, let him have a talk with all the three parties. And let him place the decision as regards to who will get the my lord.
Where is the order?
26-2,
Mr. Gogoi had submitted during the course of the order, the instruction reference to the order could not be obtained in so and so. Where is the order?
26
Even pleadings after the development of the so and so. It is pleading in the form of a pleading. Right. Okay. Okay, so there is a direction upon the respond number 1 to file an affidavit.
Yes.
Then you could not file.
So not affidavit, my lord, until and unless there is decided, my lord, there is no purpose of filing the affidavit.
Where is it? In view of about this court is of the considered view that it is the respond number in who should file an affidavit projecting the union. Right? Then,
So my lord, there is, then my lord,
as of now, you don't have unified standing.
that my lord is awaited, my lord, not to be given, that no, my lord, at least 3 weeks time, my lord, and find that. Not to be indicated in the order. Today, my lord, they have said that, my lord, all 3 weeks together will take a decision regarding to be placed in the formal affidavit.
But the court never said so.
No, not on that point, at least of going by the records and all.
Say that different departments of the state cannot have different points of view.
One can be placed.
It has to be one thing present by the chief secretary being the highest in the administration. He has to take the call. He has not filed the affidavit.
Or let it be over 2 weeks, my lord, as the last time, I will find the affidavit. Place everything, my lord, who should get it or.
Because then this time you say, after that order, now you will come up and say that earlier you said about the elections, now you will say something else, new information.
The order.
The chief secretary may change, all these things, there is no
Not
likely.
change, my lord, will be fine. Let it be 3 weeks time.
Heard Mr. So the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional advocate general appears on behalf of the respondent numbers 1, 2, 3, 6, 7, 8, and 9. Mr. So appears on behalf of the respondent number 4 and 5. This for the peruse the order dated, the peruse the materials of the court as well as the order dated 26/2/2026. From a perusal of the materials of the report as well as the said order, it revealed that the instrumentalities of the state as well as the certain departments of the state have been taking conflicting views each other. It is under such circumstances. The respondent number 1, it is under such circumstances. The learned coordinate bench of this court was of the view that the state is required to speak in one voice, and accordingly had directed the respondent number 1 to file an affidavit before this court. It is noticed that the affidavit is yet to be filed on the earlier occasion. Time was sought on account of the model code of conduct being on course. Considering the above, it is therefore the opinion of this court. Now, Mr. B. Gogoi, the learned additional advocate general, submits that such affidavit will be filed within 2 weeks' time. List this matter again on 10th of June 2026. The affidavit as directed by this court on 26/2/2026 by the respondent number 1 be filed without fail. Also.
All for, I have received the records, but it was the photocopy. Please, they've sent the photocopies of. Not the-
The SS4, hearing on behalf of the Principal Municipal Board, submits that though the records have been sent, but they being photocopied, it would be requisitioning the original reports from the Principal Municipal Board. Considering the above, list this matter again on 5th of June 2026. Mr. S.S. Roy shall ensure that the records of the teams so sought for from the Tinsukia Municipal Board in Urjugan produced before the spot on the next day.
There are two petitions. In what petition the grievance is regarding reconstitution of the petrol pump? And in the other petition, Milord, there were some artwork to be done, Milord, in terms of the policy of the Hindustan Petroleum Corporation. It should be done by the corporation itself. Whereas it was, whereas an attempt was made that the liability was foisted on us. Then we moved the writ petition. That is how both these matters stand.
So affidavits have been filed,
Yes.
so nothing remains. Meetings complete. Meetings complete.
Yes.
Agency there,
In one, yes, agency is there.
okay. Urgency is such that we have to have it before vacation or after vacation.
Before vacation. Madam. Principal give a convenient date. Madam.
What has happened with me, I wouldn't be there for 2 weeks, so for these 2 weeks, I have not fixed any matter. So they both,
No.
let me fix
Lordship will fix the matter when Lordship is there.
others are finger. Okay. Ready, even the metal, so 19th of June. Can we have it on 4th?
Third, fourth, we not have some. There's a matter in it.
11. 11,
Absolutely.
taking into account that the cleanings are complete and an urgency is shown. This matters on 11th of June 2026, on which day an attempt shall be made to dispose of the
Well, in one of the case, Mizoram has not filed the affidavit just I am told. Second one, they may do some in the meantime.
Any given opinion. Mr. K. Chaudhary, the learned senior counsel assisted by so and so, who is existing. MSP, sir. That the matter is urgent. It is also seen that the most of the respondents have already filed their pleadings except the state of Mizoram. Ms. P. Chakraborty appearing on P. Bhattacharjee, the counsel appearing on behalf of the state of Mizoram, additional advocate appearing on behalf of the state of Mizoram submits that she would be filing the affidavit in 2 weeks' time. Taking into account the above, this matter on 11th of June 2026. The state of Mizoram shall ensure filing of their affidavits on or before 2nd of June 2026. Liberty given to the petitioner to file any reply thereagainst. Attempt shall be made to dispose of the petition. Later. This is the second. The plan have appeared on behalf of the petitioner on call. Mr. H. Gupta. How are you, Mr. Gupta? I'm fine. Lot of adjournments being sought for that you are not well. I'm fine. You are appealing for oil? Oil. Are you see? You see. It's the H. Gupta appears on behalf of the respondent number 124. What is the case?
No, this is regarding certain contracts were made, they were transporting oil to the army authorities.
It's circular. So
They
far
have
as
been blacklisting due to supplying less oil, they have done some tampering with the standard fittings. In the
they
vehicle.
have not filed a reply also. For the main end of justice, today, none has appeared on behalf of the petitioner. For the end of justice, this court adjourns the matter today. And directs the, and again, to be listed again on 10th of June 2026. It is observed that if the respondents, if the petitioner is not represented on the next day, this court may be constrained to pass orders with these directions.
Well, in this case, they have pilot. They have reply in this case.
Huh?
They have reply to the opposition plan whether.
Do you want to file something?
Yeah, reply, file.
If it is opposition file, you want to file reply?
Yes, they have file.
You file reply. Then what do you mean? Nothing. EV auto. Oh, I remember. Not being allowed to fly where in Dibrugarh, huh?
Municipality area.
Reply will also have been filed.
Today file.
You have filed today. The council appearing on behalf of the petitioner submits to their reply. Certificate reply has already been filed. However, today, the same is not in the court. It's this matter again on certification. On 27, 2026. Registry shall bring on the same and be. How much? Mr. Ganguly, what is this you are payment of contractual dues because they were department, PHE. PHE, what is this? Are you admitting to the amount?
We have just received the instruction, my lord, we will file that.
What is the instruction?
Instruction is something regarding fund demand is there, my lord.
Contract work admitted,
I will have to, my lord.
contract work admitted, The moment you're saying fund demand means there is some admission, do we do the work or not? How much he is entitled is a different thing. I'm only asking whether that work order was issued to the petitioner.
I will have to verify the documents. I just received my lord, email. At some moment, that is what.
What is the movement for you? You pay within 6 months. I am not writing you now. This is the work order of 2020. How long are you going to have it? Certificate of execution being given. How much amount?
11,56,000.
All your people have signed it. Completion certificate also given. These are 5,40,000, 41,000, two comments. Why you are filing two petitions or why, means she does all the works combined together?
No, it was the project was actually same, but works were two different. Scheme is same, two different works.
What two different?
No, this is, there was a defunct public water supply scheme.
Restoration of defunct CP
Yes.
for EWSH.
Yes.
And the other in Baldwin Kachari.
Yes. Place is different, but scheme is same.
Amount is same.
Amount is not same.
5,41,000 and the other is 5,40,000. So it's 11 lakh,
It's 11,50,000.
10 lakhs 90,000. Why do you get the 46,000? Where do you get that? If these are the two amounts, then why you are saying 11 lakhs?
The bills were submitted.
Huh?
Bills have been submitted.
No, being submitted, where is it? Submitted, kindly see these two amounts. Page 39, certificate of execution.
Completion certificate, that they have said.
But the two amount comes to 5,40,000 and 5,41,000.
Yes.
Both together comes to 10 lakhs 90,
Comes to 10 lakh
91,000.
But in the proof of submission of this, that page 44, we have given that document.
Payment already made zero.
The payment is zero. And actually, some of the bills were lost.
I don't, a fund demand from executive engineer was placed to chief engineer. Let the chief engineer verify and found from chief engineer side.
We can pass that order only. The chief engineer verified. So therefore, my question is, do you admit the works were allotted to the petitioner?
From the executive side, yes, sir. From division, it is said.
So whether he is entitled to the amount is different. Whether the work has been completed by the petitioner or not, these are aspects which should be clear. So we report that work was allotted, but his entitlement is to be verified. Okay. It comes, sir. Which are comes. 5,40,000 and 5,41,000. Where do you get 11,56,000?
No, there were two bills, 510, 2020.
No, there are two bills. There's been categorically mentioned. Two work 5,40,000 and
No, but page 44, if you lordship. Page 44.
Mr. So submits that he would like to file an affidavit in opposition. Okay, this matter again on 25th of September 2026. In the meantime, affidavit in opposition be filed with the page.
Before the date, he has been waiting more than 6 days. Not some, in July, late July.
All July. All non-payment of who affidavit be filed on our payment. The PHE department, an affidavit filed by the chief engineer of the PHE on or before 17th of September 2026 as to whether the petitioner is entitled to wrong estimate. All right.
So check the respondent has filed an affidavit received the same on 16th.
Yeah,
Yes.
why you not filing?
16th.
You filed
Yes. Well,
auction report. Huh? Oh. Madam Udas, the learned counsel appearing additional senior government advocate submits that an affidavit has been filed on behalf of the respondent authorities on 16/5/2026. However, the said affidavit is not on record. List this matter again. You want to file reply?
I'm Paul on behalf of J.M. Chaudhary. It's,
You want to file reply?
yes, Your Lordship.
Ms. So-and-so appearing on behalf of the petitioner submits that petitioner would like to file a reply. List this matter again on 29th of July 2026. In the meantime, the petitioner will be at liberty to file a reply.
Lordship, Lordship.
Registry shall bring on record the affidavit filed by the state. Contextual views, Lord. What is the matter about?
Contextual views.
This is contractual views.
Under
Were completed in 2029 and you have filed this petition in 2026.
2019, Lord.
19. It reference and back in request to be able to detail report regarding the matter and necessary documents. Mr. J. Hendrick, the learned. Maybe. Planning council of the revenue department submit that taking into account that the work in question were completed in the year 2019, if some more time will be required for obtaining the necessary instruction as to whether the petitioners are entitled to the amount they claim. In that regard, further, the council further submitted that the PC Dhemaji have been requested to provide various documents by the Revenue and Disaster Management Department, and it is pursuant to such documents being placed, such verification being carried out, would be carried out. Taking into account the above, this matter on 9th of September 2026. In the meantime, steps an affidavit be filed on or before we filed on or before 2nd of September 2026 by the Revenue Department as to whether the petitioner hearing are entitled to the amounts as claimed, and further as to whether any amount in the meantime have been reversed to the question. List accordingly. Published. What is your instruction?
Instruction for the admitted amount is one of 1,91,396.
How much?
1,91,366.
Where is that document? But he is asking for a lot of money.
Some amount has been.
Why is this given for different petitions? One petition.
Two petitions are there. 127.
Hello?
Chicken find para 4 of the past paragraph, chicken find amount. The outstanding liability. Some amount has been paid, madam. Details of the amount paid is already, has already been given, madam. 1, 2, 3, and 4. Paragraph 4, madam. Yeah. And how many? After the same.
For the period from 1/3/2020 to 31/3/2020. That is there. 1/4/2020 to 34/2020. 1/5/2020 to 31/5/2020 and 20. So, Mr. Counselor, kindly come to page 7, serial number 1, serial number 2, serial number 3, and serial number 6. These total come to 1,91,396. Remaining has been paid. I have to get section from my, what from the section will be cut from the client? Huh? So you want to obtain instruction, no? Anyway, you do one thing. Whenever you file anything, ready. This so and so. You approve the Colonel additional senior government advocate submitted maybe obtain the instruction. And the amount so payable to the petitioner is not rupees 6,34,664 as claimed in the with petition, but rather an amount of around 1,91,396. So. Taking into account the said cell, in the opinion of this court, that the said aspect be brought on record by filing an affidavit, so that the petitioner could also make necessary verification and file reply there against. This matter again on 24th of July. Now you file the affidavit in 1 month. So this matter again on 24th of June 2026. In the meantime, reply be filed on or before, affidavit in opposition be filed on or before 16th of June 2026. Liberty given to the petitioner to file reply there against.
So, madam, saying, it is 1,16,571.
How much?
1,16,500.
Claim to that bullshit. Yeah, it's 1 lakh
16,500.
admitted.
That is admitted. Now.
You want to go with that? Yep, but here is 157. It will hit to paragraph. Can you give it to us?
Mike.
Include it there. Instruction of paper report. 1,16,571. Paragraph 6. Paragraph 5 of the right being delivered to spoken in 5 and 7. Huh? Taking into account the payment we made in 6 months. Huh? To the unofficial page. All right. That is related to settlement of harmony. Way to people in 12. Then what happened? What remains in this case? And that there is a condition that if value is offered by, that I know.
That I know 13A. But my question is what remains here? We are ending, June has come, June. Why you are fighting this litigation at such a late hour? When will it be given to him? 19.
19. Take from 2025
Then why have you approved this so late?
Lordship, we have obtained lordship to this, we have filed this on 22/1/2026.
So what? 19. And that to you, when you have been given for such a long time.
That to obtain to
Then
go RBI, some time has taken.
it is complete. So you are appearing for the press for it. The ground that was the notary done.
Also, for the CS is concerned, my lord.
Last time they had seen that notary is not required to keep the account of the commission is otherwise not only.
That is contrary to the resolution of the committee lordship. Resolution is accept my.
38.
30, my lord.
And my lord, second.
Right? What is the insufficient document?
My lord, if your lordship kindly come to pay error,
Oh, it will be here, na? It will be clearly given. What is the name of the petitioner?
Ismail Hussain Mundol.
Iman Ali.
Even Ali is the respondent number 8.
Ismail Hussain. Yeah, what did you give to non-encumbering certificate? Then NUC from Kopakara. Fitness certificate. License. He did not give the fitness certificate of the license of the boat.
I have a look to page 28, that is the resolution, in which is that CS is contrary with the resolution. The committee has accepted my bid, lordship, page 28, your lordship may kindly see. And 29 is the relevant.
It has been given to Imran Ali.
Even all. Well, up to serial number 1 to 4, their application of page 29.
Yes.
Serial number lordship 1 to 4, their application has been rejected. And my name appear lordship in serial number 5. Their application rejected, but serial number 5 and 6, their application allowed, they offer allowed.
Where did you get this document?
But the relevant document that we have lordship annex page 55, Jama Bundu.
Was the Jamabandi required?
But there, it is the rejection option, nothing has been stated. Only they have accepted my, accepted his bid value on the ground that he has submitted more document, lordship page 30. Page 30,
Page 30.
lordship.
Has comparatively submitted more documents than inside, and hence the court for so and so here has been decided to settle in favor of the which one to proceed.
That is the result. More document.
Any committee? It is usual, in the Gram Panchayat. this Gram Panchayat, then so you say that a lottery should have been done.
Yes, that should have been done.
Huh?
Just clarified, my lord. My lord.
Why don't you both compromise 1 month there? I can very well set aside the fact that you are not going to get it.
Would be,
No, you are not going to get it because they are not going to go for a new tender.
yes.
He is not going to get it because I'll strike down him. And therefore, they are going to run under 105. So better off, why don't you both compromise and come up the next 15, 30 days both of you run 50-50. Do something. Because otherwise, you see, you are not going to get it. Mr. Khan, you are not going to get it.
My petitioner has already given an offer to him for consultation,
Huh?
but he is not agreeing. I have lost such instruction, my lord.
Okay, let us then, we will have it again on Friday. Give your instruction as to whether
Next week,
Friday, Friday, give us that concrete here that you are going to compromise with him. If you don't, Friday, I set aside.
Yet also, my lord, CS is not signed by the court.
Or Friday, I make it CAB to make it on Monday, you get the judgment.
But the super CAB is substituting sponsor on concern lawsuit. That is signed by two bodies, the secretary or president, not by the committee. Is
Wherever the committee or whatever may be, unless they show us, barely giving more documents would not make a sense. Whether if essential documents are not given, all should have been rejected. But that cannot be the reason which is being given on you. Madam, you get your instruction why it has been given. If the matter has been filed, notice has been issued as far back as on 6/2/2026.
So far, CF is concerned, record is also required, because CS has many insufficient documents, madam. So what documents they have submitted for by this? Your lordship just reduce the CS, my lord.
Madam, you get your instructions. Because you say that he has been given. The tender is considered due to submit almost all verified documents.
My lord, colleagues have been shown that insufficient documents. So, my lord,
So
what
get your
what is
instructions
required, my lord?
on Friday. It's the matter on Friday on which date Ms. Henbora, the standing counsel of the PNRD, shall obtain the instruction as to why recourse to clause 13A of the tender document or of the notice inviting tender was not taken. Inasmuch as the petitioner's bid amount was similar, it was the same to that of the respondent number 8. In addition to that, the learned counsel shall also, standing counsel shall also obtain instruction as to what documents the petitioner did not submit, whereas the respondent number 8 had submitted, which played a role in granting the contract settlement in favor of the respondent number 8.
Madam, please, madam, settlement was, madam, allocated to the respondent number 8, madam, on the basis of the, madam, fabricated document. Can we have a look? Page, madam, 54 minutes. This total loss from it. He has signed this affidavit on 24/6/2025. And kindly have a look at the page 58. He died on 35/2020.
No, the question is on the question of fabricated document. Why
Is it-
didn't you say about that earlier?
Earlier, that petition was not a rejected expert, I have not appeared on. I have not appeared.
Huh?
That part of I have not appeared in that proceeding.
Who filed the earlier petition?
As for number 8. Earlier, my lord, I was alluded, my lord. That was silence, my lord.
You are Megan Gogoi,
Madam, I am Viman Gogoi.
and Gogoi.
Right.
Where you respond number 8.
8. In the earlier proceeding. So I could not appear, my lord.
But in taking into account the because of strong case and without interpretation, it stage the notification by which it was drafted. Okay, then what happened?
After that, madam, this order, page 51. Page 51.
Better over.
Megan Gogoi was alluded.
Clear. The petition is bid of rupees 10%. Much in the worries of the 10 value influence. Considering the income notification which then was the favor of the respondent aid. The favor. Respondent taking the particular. Okay, so I interfered with
Your lordship interfered.
your thing. But you say,
But
with your settlement,
my settlement.
now you have come
Madam.
challenging their
Telling my lord, the order is 17/25.
pursuance to their year, Megan Gogoi has been allocated.
But
Now you say that Megan Gogoi has submitted a false document. That's your thing.
that's a question. That's the only point, madam. That's just to be said. My lord, because he signed this affidavit on 24/6, my lord, but he died on, my lord, 35. May. Who? This May, my lord. Prudun Raskwa, the father of my lord, one of us. One of them, my lord, grandfather.
That's why he's going to stand as security of friends on behalf of Megan Gogoi.
But
Not Purnapata Gogoi. Who is Purnapata?
this is the, my lord, father of my lord, Prudun Raskwa. Page 50, well, page 52, this is the affidavit, I have seen it. Page 52.
What is
This is pornography, this is on affidavit.
who is Purnapata?
Pornography is the father of Prudun Raskwa, and Prudun Raskwa is the grandfather. The original land was owned by the Pornography. This Prudun Raskwa is his son. And Prudun Raskwa,
Sign that. My son so and so is going to stand as security guarantor. But Arun Rajkot did not sign as security guarantor.
this Raskwa, he signed this affidavit on 24/6. 24/6, page 53.
24/6, yes.
Well, kind of page 57. 58 not original one, it is 34. He died on 35 May. He died on May, my lord. This affidavit is shown on June.
He died on 30th of May.
And this affidavit is shown on 24/6 June. After 1 month.
And then Arun Rajkot has also given.
Here,
There was this document there or not, this page 54. Madam, was page 54 given to the authority?
Yes, sir.
Because that other document has no value. Room transfer, কোনো transfer.
The owner also is the owner man of the land.
But what did he say? He says, my son, Guru Rosford, is going to stand as the surety or directly.
But the second one, that I am the owner, recorded potato and title holder of the plot.
And he says that he's the possessor.
Ruling the. Don't also say that he's the.
So this is the.
This is the son and commander of father.
Madam, I will look into that.
I have the original copy. I have the original copy.
Madam, you haven't filed it.
What's it,
Why? When are you filing?
what's it next time?
Period will end when?
No, no, he was already noted.
When the period will end? He wants, we have to urgent. You file it within.
That's it, after the passing of this, earlier order, received, they preferred a review, also. And review,
You will dismiss that, you will so.
or non-prosecution. But the earlier notice, when officers issued the court object for question of mention.
You do that, not like. The journalism. Due course of action.
Although action is failed, but actually, like this. Inability. To bar whom? Bar you. You are the person who filed your petition earlier. He did not file. How can he be barred? The litigator
Because
would not come
at
into
that
the
point,
issue.
it was pending, also. It is not maybe.
2017-10. And you run for 4 months. It's only a fight, you can't get it. He also can't
You
get
have
it.
to, stay order has been personally.
Stay has been granted.
Not possible.
Where?
Page number 47.
No, who has done?
No, not at this photo.
Who are you?
This page 41, ma'am. Page 40.
Okay, anyways, you file your affidavit. It's the so-and-so, Miss so-and-so, the legal counsel appearing on behalf of the respondent number 8. Submits that 2 weeks time may be granted to find the reply. Affidavit in position. It's envelope. The legal standing counsel of the PNRD department. It's also directed to obtain the necessary instructions on the basis of in respect to Annexure G and Annexure H. In as much as Annexure C has been shown to have been affirmed by one Konok Rajpur on 24th of June 2025, whereas the Gaukada of Muthurapur Bhopandgaon had given a certificate that Konok Rajpur had expired on 35/2000. 25. List this matter again on 10th of June 2026. Affidavits be filed on behalf of the respondent number 8 on or before 2nd of June 2026. Liberty given to the petitioner to file reply therein. Yes, Mr. Aloy.
Here I am petitioner in the registered cooperative society. The Second numbers of fair price of bidder are being transferred from the petitioner without any intimation, no formal order that should be passed. That's number 5311.
You're running.
But we are running, but these 7 numbers of fair price of agents, they are being transferred from my society to some other society without any intimation. That's number 5211.
The cooperation department, we have no role in this matter.
Basically, government has done.
Government has done.
Government has.
If you the preliminary additional government, it submits that some time may be granted to file the reply. It is seen that on 25/2/2026, we issue. Almost 3 months is over. Under such circumstances, the final opportunity is granted to the number 1 and 3 to bring on record their stand and filing the affidavits. The affidavit we filed on or before 11th of June 2026. List the matter again on 17th of June 2026. We are also what I find. Mr. Harshola, also counsel appearing on behalf of the private also submits that you filed the affidavit on or before he took it. Fire. Island 10, then you don't appear for vote. You are appearing for 5-2.
Much.
Last storage on 8/4/26. Respond number 1 and 3. Wait for some time. Is 37 in the 18 automatic. Permission has been granted for extraction of land. But Forest Department will interpret clause 12.
Yes, Mr. Ibotabu.
As per our instruction, my lord, that proposed site that was placed before district survey report committee in compliance with, my lord, that NGT guidelines. We found that the site falls, part of that site falls in Rani Reserve. That is the, my lord, that finding.
Mr. Ibotabu, the standing council that instruction that the proposal of the petitioner for permission to extract earth from the plot of land was placed before the district
Survey report committee.
survey report committee as mandated comes with the National Green Tribunal guideline. Upon survey being conducted, it was found that part of the state plot of land falls within Rani Reserve. In the opinion of this court that the state expect be brought on report by filing an affidavit and further enclosing the report of the district scrutiny committee. Mr. Ibotaku, the learned counsel submits that such steps would be taken by filing an affidavit within 2 weeks. This matter again on 22nd of June 2026. In the meantime, the affidavit be filed on or before 15th of June 2026. Liberty given to the petitioner to file reply thereagainst. You file it on 15th. Only 15 means don't wait for 15. File it on 15.
I'm sorry, my lord, I have to file an affidavit. I have filed today only, my lord. The copy of that same may not be in the report, my lord. My lord, case of the petitioner is that, my lord, the petitioner implemented a project, my lord, of piggery farm. My lord, later on, my lord, in the month of October,
So you don't have urgency.
my lord,
I gave you time for more than 1 month to file it. You file it today on 18th. So there's no urgency.
my lord, actually, the petitioner collected the scheme from the department. That's why, my lord, he took some time, my lord.
Why do you need it from the department? It is all available in the email. That day I was taking up a matter, this council said. He did not produce any guidelines. I searched it out from the internet and got it.
I got it, my lord, but there are
That was
so many, my lord.
because he's a agent in a council out here, so it's the duty of responsibility. Not for you.
That is correct, my lord, but there are so many, my lord, guidelines, my lord. Which one is applicable to the petitioner is not known to me. That's why, my lord. Otherwise, I can download it on my internet, my lord.
Your file, you got a copy. Got a copy. It's highly apply. But you not highly applicable. What? And this money comes from whom?
From the central government, my lord.
Central government will be paying.
No, my lord, I am sorry, my lord, I have not met party central government.
What else?
My lord,
Why do you pay?
my lord, basically, I have filed, my lord, for disposal of the representation. For disposal of the representation, my lord.
I didn't talk to you.
My lord,
Mr. M. Thinker, the council submits the you find the issue. Over the same in it's the matter of 3rd of June.
my lord, can,
I'm not going to it's in consideration.
by that time, I will file an application for engineering.
Make peace of motion. Another group, while Bharat Raman has newly engaged counsel in this matter, Ms. Deva Lordship liberty to withdraw this petition with liberty to file afresh. What is the matter, bro?
Madam, the matter is regarding the tea estate, which was in default of PF dues to the tune of 6.7 crore, and thereafter a receiver was appointed for the period of 12 years with a particular payment schedule. My instruction is that we were willing and ready and able also to sell some of our land and properties to pay the entire dues at one go. But because of the injunction on the sale, bar on the sale of the lands of the entire TSA, our hands are tied. We have no income source, no revenue stream to pay the dues. Despite that, my lord, there are certain allegations, other documents also which we desired to bring on record, but these have not come on record, unfortunately. A different color has been. Yes, ma'am.
It's the elbow of the lower council.
commissioner submits that he has instructions to withdraw the instant petition, taking into account as the petition. The legal counsel further submits that the petition has various defects. In addition to that, various necessary pleadings have not yet been incorporated. This court has also taken note of that will take no academic in opposition that was filed by the respondents. Considering the above, no prejudice should be caused. This court perhaps closes the instant petition with petition on withdrawal with liberty given to the petitioner to for the reasons explained. Yes, Mr. Sir.
Well, it's non-payment of bills, well,
Which department?
but department panchayat and road development. Is the MP and
I don't think it.
Commissioner, submission.
And but the standing council of the PNRD department placed before this court communication dated 9/5/2026 should by the Commissioner Panchayat and Rural Development Department. Thereby, the Deputy Commissioner, District Commissioner, South Salmon, Montasa District have been asked to submit a comprehensive report within 14/5/2026. The same instruction is kept on record and marked with the letter X. The Miss Enbora, the Learned Standing Council, submits that on account of the report, as the report is yet to be submitted, the instructions could not be placed before this court. So considering the above, this matter again on 3rd of August 2026. In the meantime, the respondent authority, more particularly the respondent number particularly the Commissioner PNRD Panchayat and Rural Development, as well as the District Commissioner South Salmana Mankasa, are directed to file their respective response on or before 27th of July 2026.
May still this matter leads to non-payment of contractors' demand.
Police,
Yes, madam. Some police also.
It's a mix. An opportunity may be there. This week, at the game of 22nd of July. The final find the limit on before 15th of July. And I'm giving a long date.
I'll file
So
it.
that I sit on the next day. If you don't file the affidavit, then obviously then no more trust.
We have a young.
Trust issue, we have a.
I understood. I'm deeply obliged.
Yes.
Not this is that I did it certificate is well.
Ah, yes.
Petitioner was not the certificate matter.
Yes, what has happened in the meantime?
Was we have filed our affidavit, they will be filed affidavit.
You say that.
Lordship, the thing is that Lordship, the petitioner approves the authority concern only on one form of that tender process was issued on, like, the downloaded is taken by the. And in the meantime, Lordship, they were busy in Lordship, the election duty and all.
We don't think we can defend this. We'll have it on Friday, Thursday. Strategize this, makes no sense. That you see, keeping this matter pending makes no sense.
No help.
Very past the state.
But only thing is, Lordship, the one thing, Lordship, the petitioner has approved it on 4/2/26.
But you have not granted the contract.
Only because of the model code of conduct.
The Boran knows that. When the model. code of conduct.
And Lordship.
So therefore,
This is why the order is there.
therefore, I think we would set aside. Because these are e-meets,
Not
online meets.
online.
Because the manual meet, I could have allowed them to participate, but if the technical now it's perfect.
Perfect.
So I think you need to do it fresh. Anyway, it's fine, 45. Finish it off on the open the next one.
Thursday, Lord.
Affidavit in the position has been filed by the tree. Taking into account that in the name of there's been passed by this court. This matter on 21st of May 2026. At top of the list for finance. Get them in game order, I gave spite of blacklisting.